This hearing is in the matter of case number CFI 090-2022 before Justice Rene Lemiere. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al Tamimi and Company. Lead counsel is Mr. Tom Montague Smith, KC. The defendants are represented by Hamdan Al-Shamsi lawyers and legal consultants. Lead counsel is Mr. Robert Whitehead. Thank you, Your Honour.
All right, thank you. Well, Mr. Whitehead, it's your appeal. You might proceed.
Thank you, Your Excellency. So hopefully
Can I just give you one tip? Whilst I'm delighted to be called Your Excellency, it's not a title I'm entitled to, and perhaps if you call me Your Honour,
okay,
that would probably be more fitting.
Yeah, sorry. So yeah. Thank you, Your Honour. So yeah, thank you for your time today. Like I say, we act for the applicants in this case, which I'll refer to as the defendants, and my learned friend acts for the respondent, which is the Bank of Singapore. Your Honour, before us today, there are three applications. There's the first application, which relates to the defendant's request for permission to appeal the judgment that was issued and which was delivered in response to the claimant's application for immediate judgment, as you're aware. The second application, which relates to the defendant's application in January 2024, where it sought permission to appeal the costs order, which was made in relation to the costs of the immediate judgment order. And then the final application, the third application, which relates to the defendant's application, which was requesting a stay of the immediate judgment order and the cost order pending disposal of the immediate judgment application, the cost application. For the purposes of today, for the appeal hearing, the defendant's primary focus shall be on requesting permission to appeal. So we're not obviously at the stage of the appeal, it's just simply requesting permission to appeal. And I'd just like to highlight the test for this, which, as you're aware, under RDC 44.19, and this provides that for permission to appeal to be granted by a lower court or the appeal court, they must consider that the appeal would have a real prospect of success, and also that there's some compelling reason why the appeal should be heard.
They're in the alternative, or some compelling.
Yes, reason. It's an or. Yeah, it's not an and, it's an or, Your Honour. Yeah. So, Your Honour, I trust you've had the opportunity to review the parties' skeleton arguments for the hearing today.
Yes.
Perfect. Yeah. Okay. So, would you like me to summarise the positions, or can I just go straight into the defendant's skeleton, the main points?
You can go straight into the main points. Don't feel constrained.
Yeah. So, as I said, just by way of recap, we've had an immediate judgment application which was filed, and the claimant did so on the basis that they said this was a straightforward debt claim. The claimant did not apply for immediate judgment in respect of the misrepresentation claim, and the immediate judgment application was granted, and the claimant was awarded judgment in its favour. And then there was a separate costs order which the claimant was awarded also. So for the purposes of today, I'd like to focus on the immediate judgment appeal, then address you on the costs appeal, and then the stay application. So yes. Yeah, so for the immediate judgment appeal, I'll address you on 8 key arguments. For the costs appeal, I'll address you on just 3 key arguments. And then for the stay application, just some final observations on that. In terms of the immediate judgment appeal, one of the key points which has been raised by both parties is whether the appeal was filed within the time period prescribed in the RDC. So the claimant's first objection is that the defendant's immediate judgment appeal notice was not filed in time. But this respectfully is quite frankly wrong in our submission. The date of the defendant's immediate judgment appeal filing was on the 11th of December 2023, and there is a pro forma invoice which was issued on that day it was filed to prove this. We've filed this today, which has formed part of the bundle. I think, have we got a working copy of the bundle? Which page? Yeah, so it's on page 3252 of the bundle. If we can just go to that page. How do we get on yours? Sorry, I do apologise, Your Honour. It's just because we've switched PCs. Can you get it up on?
I have to access it from here.
Yeah.
I have it now, Mr. Whitehead. I'm not sure if you do yet.
Yeah, it's just because we've had to switch PCs.
Yeah.
You do apologise.
Tell me when you're ready. That's fine.
Yeah, just give. Is it this one? This one?
Yes.
Yeah. Sorry, I do apologise. So 325. Yeah. So 3253. Yeah, you can see here, obviously, DFC Corp pro forma invoice 11th of December 2023. So yeah, in terms of obviously when it was filed, it was on that date, and there's an invoice to prove that. Just under RDC 4410-2, the defendants were required to file the immediate judgment appeal within 21 days from the date of the decision of the judgment. The judgment itself was in fact issued on the 20th of November, and therefore 21 days after this date falls on the 11th of December 2023. So, you know, the defendant's submission is that it was filed in time. Under RDC 4410, it does not provide that an appeal notice must be served or issued within the 21 days, but provides that it must be filed within that time. So the defendant's position is that they have complied with this. Also, in terms of, obviously, there's separate rules for service of an appellant's notice, which is also provided under 44.34 of the RDC. And I can take you to this, but I'm sure Your Honour is aware that this is where the appellant must serve on each respondent a sealed copy of the appellant's notice, copies of any statement of the grounds of appeal and any skeleton argument, and any copies of documents as soon as practicable, and in any event within 7 days after they are filed. So again, it doesn't mention, it simply just says that it needs to be filed within that time, and the filing and service were two different things. In terms of there's one other point just to mention here, and I'm sure my learned friend will comment. There's a case of Leela versus Lickster.
It's in the bundle.
Yeah, quite right. It's in the bundle. And if we can just go, if I can take you to paragraph 11 of that case. Just let me find let me just find the case reference number. What's the number of that? Because that's just been added later, hasn't it?
It's at page 3243.
Perfect. Thank you, Your Honour.
And at 3245 is paragraph 11, which you were going to take me to.
Yeah, very good. Thank you. So here, that paragraph, the judge observed in the case that the key factor is that the claimants were willing and intended to pay at the time of the filing. So in this case, the facts in the case were also different, but it led the judge to take a different view at paragraph 11, and it was that intention to pay at the time of filing, which is obviously the case here as well. Because we sent an email to the claimant's solicitors, which is also in the bundle, got a page reference of that, where we wrote to the claimant's solicitors to explain to them that we'd made the appeal filing and emailed them on that date. So, and that's 3254 of the bundle. Just go to that. Okay, yeah, so you can see we just said here, Your Honour, that we've sent this. It's from Rachel of our office to Jonathan of Tamimi, just to say we're right in relation to the case and have filed a request for permission to appeal the judgment, and the defendants are awaiting issuance of the sealed copy of the appeal notice by the DIFC registry. So that's the first point we'd like to make on the immediate judgment appeal.
Why did you not pay the fee when you lodged the appeal?
So I think when we got the invoice, we then sent that to our client, and then obviously our client then there was some time period, logistical time period, within which they had to pay. So I think there was just perhaps a delay of, what was it, like 12? They paid the next day, didn't they? Huh? They paid it on. Oh, 1 week later. Okay. So yeah, so there was just a slight delay on that, but they certainly filed the appeal within the period required.
Why didn't you pay the fee when you? I understand this was the appeal was lodged electronically, wasn't it, on the e-filing system?
Yes. Yeah.
Why didn't you pay the fee then?
Well, I think it was our client, Your Honour, who we filed the appeal and we sent the instructions to our client, and I think our clients had some issues in terms of the banking issues. Obviously, we've had this case, so I think there was just a delay logistically from their banking side to pay the fee.
Because in the ordinary course, isn't it the case that you pay the fee when you lodge the appeal or application, whatever you're lodging, you pay the fee at the same time? Isn't that the ordinary course?
It's often, but not necessarily. I think provided you've filed the application, there is a period of time the court gives the parties filing the application to pay the fee. I think even in the invoice, it says within 7 days. So if we just go back to page 3253, in there.
Sorry, 3253, yes.
Yeah, I'm just looking now because
payment term immediate is what I see in the top right hand corner.
Yeah, that's correct. I think, but on the emails, do they not? I'm sure on the email. I was just going to get the email from the DIFC court, which was sent with the invoice, and I seem to recall there's a payment period time. But I would need if you could just allow us to check that point.
Yes, all right. Well, you can come back to that if you want.
Yeah. So the second point I'd like to address here is this: the application of the applicable law, and our position as a defendant on the Fidel versus Felicity.
Just before you go that.
Yeah.
If I was to find that you're wrong about the time, does that mean that's the end of it? That's the end of your application?
So we've made 3 applications. The first one is on the appeal. The second application is on the costs, and then the third application is a stay application. But in terms of, I mean, if you were to find that it wasn't the substantive appeal wasn't made in time, then the other 2 would obviously be impacted and follow from that.
Well, I was dealing with the first one first. If I was to find, contrary to your submission, that it was not filed in time, notwithstanding that it was lodged on the electronic system within time, but because the fee wasn't paid in time, it wasn't within time under the rules. If I was to make that finding, does it follow that your application for permission to appeal against the immediate judgment must be dismissed?
It would certainly follow, because if you're not in time, then that's.
Right.
But we would obviously, for that, we would say that would be against the overriding objective and against the course of justice. to do so within a day or so. It doesn't make sense.
Well, there are two questions there, aren't there, Mr. Whitehead? The first question would be whether, or three questions perhaps, whether on the proper construction of the rules, you're right that by lodging it electronically you were within time, or the claimant is right that you're not within time unless the fee is paid within time. That's the first question, the proper construction of the rule. The second question would be, if I'm against you on that, do I have any power to allow the permission to appeal to go forward, notwithstanding that? The third question would be, if I have power, should I exercise it in your favour? And that last point seems to be, I think, the one you were addressing, that if I have power, then I ought to exercise it, having regard to the overriding objective. But the first two, perhaps, you must overcome the first two first.
Yes. Yeah.
Whatever I think about discretion, whether I think would be just and you ought to be able to appeal. If I find that I'm against you on the construction and I have no power to do anything about it, then, well, perhaps I shouldn't say that. If I find I'm against you on the construction, and that's the totality of your application, then that would seem to be it, wouldn't it?
It would, but I think we would then have to make.
And I say that I shouldn't. I think I should be a bit more transparent about this. There is no application for an extension of time. You've not made an application for extension of time, and hence my discretion is not enlivened.
Well, I think we would certainly make an application for. We'd have to make an application for relief from sanctions.
Well, you haven't made an application, is the problem.
Because we don't think it's necessary, sir.
All right.
Yeah. So, shall I address on the other points?
Yes, please.
So, in terms of this, the next point is the defendant's position on Fidel versus Felicia case on foreign law.
Yes.
So this kind of appeal is on a point of law, and in the judgment at paragraph 88, the court recorded that the parties had conducted the application on the basis that the contract law of Singapore, including the interpretation and implications of terms, is the same as the contract law of England and Wales.
Yes.
Yeah, the defendants have maintained that the law of Singapore applies and have not conducted or said that the application on the basis that the contract law of Singapore is the same as that of the law of England and Wales. At paragraph 89 of the judgment, it also states that counsel for the defendants did not express any disagreement with that approach. But our respectful submission here is that it cannot be inferred that no objection would be a concession, because counsel for the defendant actually did explain that.
Can I take it a bit at a time?
Yeah.
What 89 says, counsel for the defendants did not express any disagreement with that approach. Is that correct, or is that not correct?
Well, I think on that, it was a case where each counsel had an opportunity to provide submissions, but there was no direct obligation by either party to address that point. So both parties gave their submission.
My question, Mr. Whitehead, was not whether you had an obligation to do it, but is it correct that the counsel for the defendants did not express any disagreement? You might tell me you might tell me why you didn't, or you didn't have to, or whatever. But my first point is simply: is it correct that you didn't express any disagreement with that approach?
I don't think we specifically disagreed, but that again wasn't a concession by not disagreeing at that point.
Yes. All right.
Okay.
You agree with that, but say it doesn't amount to a concession that it's correct.
Yes. Yes.
All right.
So for this, we did explain that the law of Singapore should apply, and that the courts ought to appoint an expert on the law of Singapore in relation to the defendant's defence, and that the parties did not agree that the law of Singapore should be read to be similar to that of the contract law of England and Wales. But it was on this point of dispute that the defendants were directed to file further submissions in relation to the case of Fidel on the 16th of October 2023. And on this, the court's conclusion was, as far as we understand.
Is that what you were asked to file submissions on? You may be right, but my recollection was that the request was to file submissions on the Singapore case of Lim Ziping and Xiao Swat Tin.
Yeah, so I think first it was on the Fidel case, and then second it was on the second case you just referred to.
Right. Okay.
Yeah. So here, in our submission, in the Fidel case, the court did observe that the relevant approach in relation to foreign law should be discussed at the case management conference. And the court also went on to explain in this case that the subject of proving the content and interpretation of all the non-DFC laws should be in line with the overriding objective. So our position here, Your Honour, is that the case does involve complicated banking questions and issues, and the defendants are required to defend a claim which is brought by the claimant for a significant amount of money. And the defendant's position here then is that the courts ought to treat the law of Singapore as a fact and allow counsel for the defendants who are not qualified in Singapore to lead evidence via an expert. So, but
Mr. Whitehead, tell me why this is not right. On the application for immediate judgment, it was up to each party to make relevant submissions and to put forward relevant evidence. If a party contended that the law of Singapore had certain content, that the law of Singapore in relation to implied terms had made certain provisions, then it was for that party to bring forward that evidence at the hearing, was it not? It surely is not open to a party to say, in effect, we don't agree that the law is what the other side say it is, but we're not going to tell you what it is. You really ought to just put this off to a trial, and then we can have an opportunity to tell you what the law is then. That, in effect, is what you're saying, isn't it?
I think the burden for the immediate judgment is on the claimant, isn't it? So as a defendant, we've really, in terms of going as far as where you've said there, it seems quite cumbersome for the defendant to have to do that at that stage, given that a case management conference stage, that's where it would be dealt with traditionally.
Well, I think what the Court of Appeal was saying in the Fidel case is that, in effect, it would be prudent to deal with it at the case management stage, that would be advisable, but they didn't say anything to the effect that if that's not been done, then the court cannot or should not consider at a hearing what the foreign law is. And indeed, isn't the court obliged to consider what the foreign law, when I say foreign law, whatever the governing law is? When we get to, it was common ground and remains common ground that the law of Singapore governs the contract. That's your submission and it's common ground. Then in effect, the claimant said, the law is, it's the same as the law of England, and this is the content. They spelt out what the rules and principles of law are. If you disagree with that, is not the onus on you to say what the principles and rules of law that should apply are? You can't simply say, no, that's not right. You've got to bring forward why they're not right. What is the correct? And it's not enough to say, well, the law of Singapore is different from the law of England. You've got to say, surely, in what respects it's different? How is it different? What effect does that have on the case?
Yeah, so Your Honour, if you allow me, I will go into this now. Yeah, so in a case in Singapore, which has been filed as part of this hearing, there's a defendant parent company which is ARJ Holding Limited, and the second defendant in this case, they were in fact faced with a similar claim, which was brought against them by another bank. And here in this claim, the claim was in relation to a loan which the defendant had allegedly not repaid. And similar to this case, the bank terminated the loan facility and filed a similar summary judgment application for repayment of the loan together with interest. The defendants in this case also raised a similar defence to the defence which have been raised by the defendants in this case, that there was an implied duty upon the bank to not act perversely, irrationally or capriciously. And when deciding when the defendants had raised a triable issue...
Can I stop you there, Mr. Whitehead?
Yeah.
You're referring, are you, to the decision in Deutsche Bank AG Singapore branch and AJR Holding Limited and Muhammad Ahmed Ramadan Juma, which is at page 3174 in the bundle?
Yeah, I think I'll just check you on it, but my reference is 2399, but is that the old one? Is what saying? Oh, the appellant court. So I think Your Honour, you're referring to the appellant court decision. So if I could just take you to the later decision, the appeal court decision, which is it 2399 of the bundle.
2399.
And if I could just take you to paragraph 21.
So that's the High Court decision. Let me just note it down.
2399 of the bundle.
89.
2399. Yeah.
That's the page you want me to go to, is it?
Yes, please.
2399.
Yeah.
Yes, I have that.
Yeah, and at paragraph 21 on the
Right.
second line down, if I could just read this, or if we could make a note,
Yes.
It says, I will only make brief observations on the second triable issue raised by the defendants, which pertains to the existence of implied good faith terms and whether DB exercised its discretion in good faith. Here, I would agree with the defendants that these would be triable issues with reference to the authority of Edwards. And in the absence of conclusive local authorities stating otherwise, it is arguable that such an implied term can exist. So in this case, it was a similar situation, and I will come on to explain this a bit further on, but essentially what happened here, it was that the judge in this case was referred to the judgment of the DIFC court in the present case. However, it was dismissed, and the Singapore judge observed that the DIFC case appears to rely on UK authorities on the implication of a Braganza duty rather than...
Now that's in the later decision, is it?
Yes, yes. Sorry, this is this decision. This is at 2399 of that same decision.
Oh, I see. Yes, yes.
Yeah.
I see in paragraph 21 further on. Yes.
Yes. Yeah. Yeah. So that's our stance on that. In terms, before I go into that in more detail, in the Edwards decision, so it's Edwards, Jason Glenn versus Australia and New Zealand Banking Group. We've referenced at paragraph 45 to 50 of our skeleton argument the position in respect of the immediate judgment appeal, but what appears to be the case from this authority on implied terms regarding the banking is that it predates the Braganza duty. And if I could just take you to 2302 of this judgment, so page 2302 of the bundle, and it should be at paragraph 99, yeah, on page 2302. It reads that I agree with ANZ's first proposition that ANZ has the contractual right to assess the security using its sole discretion. However, a point that was not canvassed before me was whether this discretion was unfettered, and if it was not unfettered, whether it was exercised incorrectly. To answer this question, I turn to Lewison, who states the following principle. And this is the key point we'd like to highlight, is that where a contract confers a discretion on one party and the exercise of that discretion may adversely affect the interests of the other party, it will usually be implicit that the discretion must be exercised honestly and rationally and for the purpose from which it was conferred. And then it does go on to refer at paragraph 101 of the same judgment that ANZ therefore does not have untrampled discretion. And then it says, applying to the present case, I am of the view that the exercise of discretion by ANZ in using the previous valuations was not arbitrary or capricious or perverse. And that's it, page 2302 to 2303. So the defendant's submission here, based on what we've just set out, is that there appears to be, or at least exists, an implied obligation on the claimant in accordance with the Singapore law. And then if this was correct, the following paragraphs in the judgment would be then rendered incorrect, which would be paragraph 157, which says that the right of or power of the claimant to reevaluate the collateral was not subject to a Braganza duty. Paragraph 183 as well, which says that the power of the claimant to essentially disallow the first defendant from getting refinancing was justified and was not subject to the Braganza duty. And then paragraph 274, which says that the claimant had no obligation to make the full amount available on request and that this obligation was not subject to the Braganza duty. And again, as I've referred, Your Honour, before, page 2399 of the bundle, there was, in the Singapore case we've just discussed, there was a reference to the judgment of the DIFC courts in the present case, but this was dismissed, and the Singapore judge did observe that the DIFC case appeared to rely on the UK authorities on the implication of a Braganza duty rather than any local authority, which is our case for this appeal in terms of requesting for permission to appeal. And then page 3174 to 3202 of the bundle. This is the appeal by the bank of the decision in the Singapore case, and this appeal was dismissed in early March, the 5th of March 2024. Then we filed this, but the notes of evidence of the appeal on this. So if I could just take you to this, it's at 3200 of the bundle. So paragraph 42, it reads, I also agree with the defendants that there is a triable issue in respect of whether there were implied good faith terms. DP submits that the defendants have not provided any evidence that the parties intended to introduce a new term. However, the defendant's case on this relies on Edwards, etc., etc. And then obviously the case in MARJ, which is before us now, this was also relied on by AR in his DB. The bank relies on a decision that was before the Dubai courts. It should be DIFC courts in the Bank of Singapore versus MARJ, which held at 157 and 161 that the Braganza duty does not apply to a bank's valuation of collateral. Given the holding in Edwards, I found that defendants have an arguable case that the implied good faith terms applies in this context. So that's our point on that. That's the second point I'd like to address. So the first point is, which I've addressed, is the fact that the appeal, in our view, is not out of time. Then the second point is the reliance on Singapore law. Now, the third point I'd like to address is the reference to the Marks and Spencer's PLC versus BNP case, and also the UBS case, and the DFC court's reference to those. So as we've seen in the judgment, the court did extensively rely on both cases, and this can be seen at paragraph 139 of the judgment, which is at 1987 in the bundle. But our respectful submission, Your Honour, is that this is not the correct position under Singapore law or Singaporean law. The defendants are aware, also on this, the defendants are not aware of any reported cases or any Singapore decisions which have applied such cases. Then the next point, so the fourth point we'd like to address is the
before you leave that point.
Yeah.
I'm not sure if you've said it in your submissions or if Mr. Montague Smith did, or whether I've just seen it elsewhere. The leading case in Singapore, case generally referred to as a case called Sembcorp, SEMBCORP,
yeah.
Marine Limited, and PPL Holdings, PTE Limited, 2013, 4 Singapore law reports at 193. And that was the case in which I suppose one has to look at the history of things and how, on one view, the English law in relation to implied terms had taken something of a turn, and the Singapore court chose not to follow it, and instead the Singapore Court of Appeal formulated what they now referred to as the three-step test to make out an implied term. And I should pause to say they're referring to terms implied in fact, not terms implied in law. To make out a term to be implied in fact, it will only be implied if it meets the three-step test. The first step is that there is a true gap in the contract. The second step is that it's necessary in the business or commercial sense to imply a term that to fill that gap in order to give the contract efficacy, what's generally referred to as the business efficacy test. And the third step is that the term sought to be implied is one which the parties, having regard to the need for business efficacy, would have responded, oh, of course, had the inclusion of the term been put to them at the time of contract. That is what is generally referred to as the officious bystander test. So it's that threefold step which in Sembcorp it was said must be met to make out an implied term. Now, in one view, that is a stricter test than the test now applied by the courts in England. Because again, without having to go off into jurisprudential arguments, when Marks and Spencers came around, the court took the view that the Belize test perhaps had not changed the law or should not be taken to have changed the law, and formulated the test in the way in which I attempted to set it out in the judgment. And one of the points there is that it is the test put forward there, and I think I referred to a subsequent judgment which summarised the rules, puts forward the basis that you don't have to meet both the business efficacy test and the officious bystander test. Meeting either one will do. And hence why, on one view, the Singapore test is a stricter, more rigorous test than the test put forward in Marks and Spencer. The reason I trouble you with that is that it seems to me it's not enough to say that the Singapore court has applied its own test. You have to go further and say, if you apply that test, you get a different result. And if that test is, as I suggest, perhaps a more strict test, then the test in Marks and Spencer is more favourable to you, and applying the Sembcorp test doesn't help. So that if you're right that there is a difference between the Marks and Spencer test on the one hand and the test applied in Singapore on the other, that doesn't get you anywhere unless you're able to show that by applying the test generally applied by the Singapore courts would have led to a different result. Now, I've spent a little time talking. Do you want to address that point?
Yes, Your Honour. So I think, look, I can certainly come to address that, and I'd like a little bit of time just to digest that, because but I think our main point on this, and I totally take on board all the points you've raised, is our main concern was the risk of a mini trial, because if we were to go into detail on all the minutiae and address each of the tests, our view on that was simply that, you know, at least not at this, sorry, at least at the immediate judgment stage, was that this would have been dealt with at the case management conference stage and not at the you know, the immediate judgment stage. But if you just allow me a little bit of time to digest that, and I will come back to you on those points, because look, I mean, our main point on this was that obviously in Singapore, because it has its own jurisprudence and it's got its own court system, our view is that the Singapore case, the one we've just discussed, did demonstrate that the defendants had the triable issues, and there was, you know, in terms of where the defendants, you know, they didn't criticise the court's explanation of the Braganza duty under English law, but have just challenged the reliance on those two cases. And in terms of whether
on which two cases? Oh, sorry, on my decision in this case.
It's just the Marks and Spencer and the UBS one, but yeah, but
they don't actually refer to Marks and Spencers, do they?
I think there's reference in there in the judgment, as far as I'm aware, to both cases, which is what we in the cases decisions you've just taken me to. Not in the cases we've just taken.
Oh, sorry.
Sorry, no. So I mean, look, I suppose what the initial thing, the initial issue we had was why was English law being even looked at in the first place? Because obviously Singapore law governs the contract, so we would be looking to the Singapore authorities as opposed to the English court authorities, and that's why we feel, because again the point here is for this application is whether we can have application for permission to appeal. This hearing today is not for the appeal itself. It's just
no, but you've got to show real prospects of success.
Yeah.
You can't just say, "Oh, give us a go." And one of the points.
Okay, I found this on the web for show real prospects of success. You can't just say, "Oh, give us a go." Check it out.
I'm sorry, I think my phone is just going crazy. I'll switch it off. One of the difficulties arises is that, of course, none of this was raised at the immediate judgment hearing. And it's, I'm not sure whether it's a case where I should take up the point that, is it open to a defendant to hold back its reserve points, a bit like the army which keeps its units in reserve, and then when the battle has taken a turn for the worse, in this case where a decision has been rendered and it's over, then you want to bring in these arguments which were never raised at the hearing. At the hearing, the most you said was Singapore law applies, and of course everybody was in furious agreement about that. The question which you now raise is, what is the content of that law? At the immediate judgment hearing, the claimant said it is the same as English law and spelled out, I think I might be repeating myself now, but spelled out what the relevant rules and principles were, and you didn't put forward what you say are the rules and principles that apply. For example, that Marks and Spencer's was not the applicable law and so on. So it makes it difficult. But even if I assume that you can raise all those points now, we then come to the point that I want you to particularly address. That is, you're right about all of this. Does it affect the decision on the immediate judgment? For example, and I think the claimant, I don't think, I know, the claimant has made these points expressly in their skeleton argument. If you're right that you have a real prospect of succeeding in establishing that a relevant duty should be implied, the next point you've got to deal with is that the judgment finds that if such a duty is implied, it wasn't breached. Now, you've got to overcome that point as well, don't you?
I think so.
Because
I think we've certainly addressed a lot of those points in our defence to the claim.
It's not in your notice of appeal, is it?
But it's in our defence, Your Honour. So we've set out it substantively in the defence what our position is on that for the purposes of this case.
But the way an appeal works, and we're of course at the permission stage where we have to look at whether or not your appeal has reasonable prospects of success, and I then go to the level of looking at the grounds of appeal and whether each ground has a reasonable prospect of success. If there is a ground of appeal which has a reasonable prospect of being correct, but does not affect the outcome, then that's not sufficient is it?
Well,
If you're able to point to an error in the judgment, but that error doesn't affect the outcome, then you shouldn't get permission to appeal, should you?
I think that's right, but I think and I'll come on to both points.
Okay.
I'll come on to the point you've raised in terms of, yeah, I'll address both points now. So in terms of the impact of the case, so whether or not the points I've raised have any material impact on the, if you like, final decision of the claim. Yeah. So at paragraph 34 of the claimant's submission, they've relied on the clause in the facility agreement itself, which excludes the implication of any terms. And that's it.
Yes.
Yeah.
That's another point. Yes.
Yes. So 2372 of the bundle.
2377. Did you say?
2372, Your Honour.
2372.
Yeah. So this is here. What the claimant as part of their submission at paragraph 34. So it's yeah. Yeah. So they've referred to the let me just get the one begins with U. So just 2 seconds. Let me just find, I'm just trying to find the reference here. Is that the right reference? So it 2372. Yeah, so the quote is, you further agree that subject to any duties or obligations imposed by mandatory applicable.
Sorry, Mr. Rowe, what are you reading from now?
Just give me a second, because it's in the claimant's skeleton. I think there's perhaps a reference error. What I'll do, I'll give you the reference shortly. Just bear with me. But I'll read the statement, and again, the claimant can.
So this is from the claimant's skeleton, is it you're reading?
Yes. Yeah.
Yes,
Yeah.
Okay.
So it says, you further agree that subject to any duties or obligations by mandatory applicable law which the bank cannot derogate from, the bank owes no other duties or obligations to you save as expressly set out herein, and that no implied duties or obligations shall be imposed on the bank under or by reason of this agreement. So here, this is the case we wanted to refer you to, which is the NG, again, excuse my pronunciation, it's NG GAP on versus Westcombe Securities Pte Limited. So this is a Singapore Court of Appeal, and here the Singapore Court of Appeal examined similar wording, a similarly worded clause, which excluded the implication of obligations.
Is that case in your bundle, Mr. Whitehead?
Yeah, that is in our bundle as well.
Do you know where it is?
Yes, it's at 3145. It should be. Let me find it. Yeah. So yeah, that case is at 3145 of the bundle.
Oh yes. Yes.
Yeah. So here, and if I can just take you to a few paragraphs. Right. In the case, it's paragraph 31.
Okay.
So, however, I'll just read a few points. There's just a few points I'd like to highlight if possible. However, we would also pause to observe that in this point, even if there is no reference to implied terms in an entire agreement clause, it is arguable that the presence of such a clause in a contract would not, as a matter of general principle, exclude the implication of terms into that contract for several reasons. And then it goes into all the different reasons why an implied term can be used. And then at paragraph 32, it then says that by that having been said, we are not prepared to state that an entire agreement clause can never exclude the implication of terms into a contract. However, for an entire agreement clause to have this effect, it would need to express such effect in clear and unambiguous language. Further, if the effect of the language used renders the entire agreement clause in substance an exception clause, the clause would be subject to both the relevant common law constraints on exclusions as well as the Unfair Contract Terms Act. So our position here, Your Honour, is if we look at the agreement as a whole, the governing law is Singapore, the law of Singapore, and the mere existence of an exclusion clause, in our view, would not hamper the implication of the implied obligations into the contract or the agreement. And then since this purported exclusion under the facility agreement is subject to any disputes, duties or obligations imposed by mandatory applicable law, which the bank cannot derogate from, our position is that, you know, the applicable law in Singapore regarding the Braganza duty should be used without dismissing it, which is why it's important, we feel, to examine the Braganza duty through the lens of the Singapore law. So if I can just address your second point, the Sempcorp case versus the English case law point now. Here, at paragraph 41 of the claimant's submission, the claimant has explained that the defendant has not demonstrated how the test laid down in Sempcorp case was any different from the court's approach.
Right.
And I think this is the point you are referring to, Your Honour, here.
Yes.
Yeah. So we would say that this is incorrect because we've pointed out in Sempcorp that the court did apply, as you referred to, a three-pronged test to determine whether a term may be implied into a contract. And the courts relied on the Marks and Spencers and the U Design Services case. But the 8-point test has not been applied anywhere in Singapore. And in our view, we would say it's incorrect for the DFC courts to apply this to the present case.
But if in the judgment it says that the steps, without reference to the Sembcorp case, but if it finds those steps were not made out, then that doesn't help you, does it? If the judgment finds that the officious bystander test and the all three steps in the Sembcorp case are not made out, then the fact that there's no reference to the Sembcorp case is not decisive, is it?
Well, I mean, look, we would say in terms of the test itself, we would need to examine whether those steps have been made out, and that would need more it would need witness statements. It would need a thorough examination on that, which would be necessary, and that's why we're seeking this application for permission to appeal. Our case is that the law in relation to the Braganza duty is not subject to the strict restrictions and limitations which are under the English law as established in Edwards, and that we would say here that in the Singapore case, the defendants did rule that the defendants had a triable issue, which is why we rely upon case law authorities in Singapore in our skeleton argument in support of the immediate judgment. Yeah.
Now, the next point that I wanted to address is, if you're right that there is at least, you only have to go as far as real prospects of success. If you have a real prospect of success in making out that a Braganza type duty should be implied, you haven't really got there, have you? Because the judgment found that such a duty was not breached. So even if you're right that the duty should be implied, that doesn't give you a defence, because the finding was that there was no breach of such a duty. And you've got to make out both of those things, have you not?
Yeah, I think we need to, for the sake of for this application today, we just, as we established earlier, we just need to point out that it's either or has real prospects of success, or there's
Yes.
some other compelling reason. Yeah.
But if you appeal, well, we'll maybe come to that second limb in a moment. But
yeah,
on the real prospects of success, if there's no appeal against the finding that there was no breach of duty, then the appeal cannot succeed, can it? Because even if on appeal it was found that there was such a duty, the duty should be implied. If there's no appeal against the finding that there was no breach of the duty, the finding of no breach of duty stands and your case fails.
So I think we are just simply appealing on the basis that there's well, on the basis is, as I've said, but also in terms of incorrect factual conclusions which have been made.
What are the? Is there an appeal against the factual findings?
Yes. So in our skeleton.
Where is that?
So
no, in the grounds, in the notice of appeal.
I'd need to just bear. I can check that, but I can certainly look at those points. Page. So page 2069.
2069.
Yeah.
Let me go to that.
So what? Yeah. So I think, look, from paragraph 58.
This is your skeleton.
Yeah. This is. Yeah. And here, this is where we've listed the reevaluation of the Landstone bond from paragraph 58 onwards. Yeah.
And the Roman numerals 4, is that referring to ground 4 of the appeal notice?
Yes. Yeah.
Well, 4 is, that's right. Further, the CFI has applied the wrong principles of law to the defences raised by the defendants. As such, these findings have to be set aside and should be re-examined in the light of the Singapore case law. So that doesn't seem to be it.
So I think if we go to, sorry, just give me a second. If we go, it's on from 2064 onwards. This is where we've looked at all the points in our appeal.
Well, this is your argument. This is your skeleton argument.
Yeah.
But my question was whether you've made that a ground of your application for permission to appeal. And to find that out, I go to the appeal notice, and I can't see it in the appeal notice. I mean, you can't just raise things in the skeleton argument. It's got to be in the appeal notice.
Yeah. If you can just allow me to find it in the appeal notice, because I think we have raised certain points, but I just need some time to just check.
Okay.
So our situation here is we would say that there was no duty. There's a finding that there's no duty on the claimant to act in good faith. And if it was concluded by the court that all the actions of the claimant in respect of the facilities agreement could not be considered a breach, then the discretion which is exercised by the claimant is just purely a factual dispute. So our position is that once it is established that the claimant was subject to an implied duty to not act capriciously, irrationally, and perversely, our situation that it follows that this is a triable issue. Whether or not the claimant has breached this duty or not, and that's the position today. That's why we're making this application, because there's certainly a triable issue which needs to be heard, and that these shouldn't our view is that it should not be decided at the immediate judgment stage, but at trial.
All right.
And we would also say, this is in line with the overriding objective, and also to act and deal with cases justly, to give the defendant the right to a trial and actually go to trial and make its submissions. The final point I'd like to address on the immediate judgment application is this witnessing of the deed of guarantee.
Just before you leave the case against the company,
yeah,
there was another finding in the judgment that the no set-off clause precludes a set-off, and the basis of your defence was that the implied duties and the breach of those implied duties gave rise to a counterclaim, and you set off that claim against the claimant's claim. The claimant said, amongst other things, that there is a no set-off clause in the agreement, and that was found in the judgment that they were right. And that was a ground of finding against your client in any event. That is, even if you're right that there was an implied duty and a breach, and that gives rise to a counterclaim, the no set-off clause provides that you can't set off that claim against the claim due to the claimant. Now, again, as far as I can see, there is no appeal against that finding. Do you want to say anything about that?
Yes, so we would look to appeal on against that finding on the same basis as we've appealed on the other findings. That essentially the position is that, you know, the defendants have, you know, will be given the right to defend themselves and basically have the discretion to defend themselves on that point as well.
Right. All right. You wanted to move on to the guarantee.
Yes, that's in terms of the witnessing of the guarantee. The defendant's position on that is simply that the defendants had made submissions as part of its skeleton argument, which can be found at 2071 to 2073. I'll not repeat that here for the sake of brevity, but right. the claimant has provided no explanation regarding the requirements under the deed of guarantee, which states that execution before a witness is mandatory. So as part of the skeleton, the defendant's position here is that the deed of guarantee was not properly executed. And
so what was the deed? What is the requirement in the deed for a witness? Where is it? Do we have that? I'm sure it's in the bundle somewhere.
Yeah, yeah, I can find reference. Just give me.
Yes, please. If you can.
Yeah.
If I can help,
yes,
unfortunately,
thank you.
My pagination is slightly different from everyone else's, unfortunately. So for me, it is on page 304, but I think it may be in your bundle at page 300, if what we're looking for is the signature page of the guarantee. Right,
thank you.
Yeah, thank you.
Is it 300 or is it 304? Because I'd like to know from mine.
We had the same issue. Yeah, we had the same issue with when I think it's because if you download there's a change. Is that there?
I'm still looking at the circle.
304. So
yeah,
my pagination fails later in the bundle.
Okay.
Yeah, so here,
Just bear with me a minute, Mr. Whitehead. Sadly, I'm still looking at a screen with a circle spinning round. Hopefully it'll emerge. I just want to have a look at this. One of the frustrations of online things.
Yeah, it's the reason why we all, I think, download the bundles as PDFs. Unfortunately,
Yeah.
actually, this is the first time it's happened. In fairness, that seems to have led to a pagination error. So, but there we are.
Right. I found that I couldn't download this bundle, Mr. Montague Smith. I don't know why that was, but
That's unfortunate.
one of our colleagues had the same issue. I was able to download it, but one of our colleagues had it. Yeah.
All right. What is the clause? I think, Mr. Whitehead, what you were referring to is a clause that requires a signature.
Do you want to I can share it on screen if that would help, Your Honour.
Yeah, if you
try this.
If your skills
with me.
go for that.
Is it this one? Problem is, it's because I'm using somebody else's PC.
Okay. Go to the case finder.
That one. Is it that?
It won't be that. It could probably be this.
This.
Yeah.
Yeah. Can you see that, Your Honour?
Oh, yes. Sorry, I see that, but I thought you said that there was a clause somewhere that says it must be witnessed.
Yeah.
So you're just referring to the fact that the execution clause has got provision for a witness.
No, sorry. In the footnote, it's 6.
Oh, in footnote.
Yeah. So it says
execution before witness is mandatory. I've got it.
Yeah.
Right. Please provide copies of the documents below for witness. So that's interesting. That seems to be some sort of instructions about the execution. Question mark whether it's actually part of the document itself. But
yeah, so I mean, this is the final page at 304.
Yeah.
Yeah.
Yeah, I've got it.
Okay.
But
fine.
in any event, the finding is that it was witnessed, isn't it?
Yeah, just not before a witness, though. As far because
execution, no, execution before witness is mandatory.
Yeah.
But the finding is that it was executed before the witness. The witness was present.
I think there was a lag as far as I need to check. But as far as I understand, if I could stop sharing my screen, Your Honour, if that's
yeah,
okay.
yeah, sure. You can take that off now.
Yeah. So yeah, so I think what the issue here is that under Singaporean law, there is no requirement that deed be witnessed. But Mr. Juma's defence here was that the guarantee is unenforceable because Mr. Satney did not add his signature as witness in the presence of Mr. Juma. So that's it. Which one's this? 370 of the judgment. Yes, of your judgment, you've referenced this in your judgment.
What I'm putting to you now, Mr. Whitehead, is again, if you're right,
yeah,
does that affect the outcome? Because I went on to find in the judgment that it was witnessed, it was executed in the presence of the witness. The witness didn't add his signature in the presence of Mr. Juma, but Mr. Juma executed it in the presence of the witness.
Yeah, I think this is the point. I think this is what we need to go to trial and at least have witness statements to examine what in fact did happen or not. Because as we can't, obviously, we don't want to sort of speculate or make assumptions on that. That's the only point here, Your Honour, we're just trying to address. I just
want to make sure get right. The wording at the bottom of that page was execution before witness is mandatory.
Yes.
what that is saying is execution, that is signature by the guarantor, Mr. Juma, before, that is in front of the witness, is mandatory. Now, I found that it was executed by Mr. Juma before, that is in the presence of the witness. So that requirement is met. Your argument on the immediate judgment hearing was not that there was a failure of execution before the witness. Your argument was the witness didn't add his signature at the time or before Mr. Juma, because what happened was that Mr. Juma witnessed, sorry, the witness witnessed Mr. Juma sign it. Then the witness left and returned to his office. And it's when he returned to his office that he then signed his signature as witness. And your argument was that that invalidated it.
But I think that was slightly different at the immediate judgment application hearing, wasn't it? Because we didn't go to that clause at that hearing. So
no, you didn't.
Yeah.
Well, I don't remember you doing it.
No. So I think what our point here is that we just feel it needs to be examined, and there needs to be the witness statements and a trial to at least come to terms on that point. There are my points on the immediate judgment application, and then
did you want to say anything? You want to say anything about the interest question, or will you rely upon your skeleton argument?
On the interest, we primarily rely on the points in the skeleton, but yeah, I mean, unless there's anything you would want me to address on that specifically.
All right. No, all right.
Okay. Yeah. So in terms of the cost appeal notice, there's 3 points we'd just like to briefly make on this, and obviously that stems and flows from the immediate judgment application notice. So the defendant's position here is that the claim it's not correct in our view to say that the claimant has succeeded with its principal claim. Firstly, and I'll come to the reason why on that shortly. The second one is that there's this issue-based cost order which has been passed, which, as far as we can see, Your Honour, isn't under the RDC. There's no provision for that there. And then the third one is that in awarding costs, as well as the cost of the immediate judgment, we would say that position isn't the correct position either. The first point then, in terms of the claimant succeeding on its principal claim, under the court considered whether the claimant was successful in part of its claim, which obviously it has discretion to do under RDC 38.82. But in our view, the court went beyond this discretion by saying that the claimant, by succeeding in only part of its claim, has effectively succeeded in all of its claim. So from a costs point of view, at paragraph 42 of the costs order, the court said that the claimant had succeeded in its principal claim by obtaining relief in the claim, but had perhaps obtained relief for the entire claim. I think the word perhaps is referred to. And then it goes on to say at paragraph 50, the court then recorded that the claimant would be the successful party, whatever the outcome of the misrepresentation claim, which was based on the fact that the principal issue, which was the debt claim, was ordered in favour of the claimant. The claimant did not, however, state that the debt claim was the principal claim, or that its misrepresentation claim was a secondary claim, as far as we understand. And the claimant has, as far as we understand, in no point or in the particulars of claim or otherwise, submitted that the debt claim and the misrepresentation claim are connected. So our submission on this is that the court has then gone beyond what we feel would be its discretion under RDC in its 38.82 to arrive at the conclusion that the claim has succeeded in the entirety of its claim. That's the first point. The second point on this is this issue-based cost order. Our position as a defendant on this is that it's not provided under the RDC, and in granting this does go beyond the purview of the RDC. In paragraph 44 of the cost order, the court directed that the issue-based cost order would be appropriate. However, our view is that this isn't correct because there's no specific provision under the RDC which allows the court to grant an issue-based cost order. And under RDC 38.12, there is a list of orders which the court can make regarding costs. And as far as we can see, there's no provision to make the issue-based cost order. The final point, just in terms of costs and the cost order, is just to refer to the costs of the entire case. So our position is that costs of the entire case cannot be awarded because under paragraph 18 of the judgment, the claimant has not applied for immediate judgment on its misrepresentation claim, and as such, the judgment does not dispose of the claimant's misrepresentation claim, which essentially, as far as we understand, would remain open. The claimant has also not filed a notice of discontinuance, so that does remain undetermined. And under RDC 38.12, this provides that costs in the case relate to costs at the end of the proceedings. So essentially, the defendants have relied on the case of Oshlak versus Richmond River Council, and we'd invite, this is referenced, I won't go into because it's referenced at paragraph 38 of our skeleton argument, and our view is that to award the claimant its costs of the entire case would be exorbitant, and therefore costs in the case should not be awarded. The final point just on costs, before I just make a brief point on the stay application, is that the costs order, in our view, obviously would be redundant where the defendants are granted permission to appeal the judgment. So we're saying here that if
the cost order would fall away,
yeah,
if you were successful on appeal.
Yes. Yeah.
And
it
hence,
would.
If you were given permission to appeal on the immediate judgment, you should be given leave to appeal on the cost judgment, notwithstanding the grounds that you have put there. But Mr. Montague-Smith might tell me otherwise.
So on this, we're essentially, as you said, Your Honour, we're saying that if the defendants are granted permission to appeal the judgment, and if successful in their appeal, then the cost order would be rendered obsolete eventually, if that was the case. So our position on that is that's our position on the costs order. So the final point is the stay application. So the third one, in terms of the stay application, the defendant's request is that for the court to grant a stay of the judgment and the cost order in accordance with the overriding objective. And
so this is a stay pending the appeal decision.
Yes. Yeah. So we've referenced in our skeleton two main DFC legal provisions, one of which is Rule 4.26 of the RDC, which provides that except where these rules provide otherwise, the court may, and then point 6, stay the whole or part of any proceedings or judgment, either generally or until a specific date or event. So there's authority to do that under the RDC. And then under Article 33 of the DFC court law, the DFC court may, if it considers it appropriate, stay any decision, order, or proceedings as required. So there is provision for us to do for that to happen. What we would say is that if the stay is not, the defendants, if the stay is not granted, then the defendants will be prejudiced because they'd have to commit a significant monetary sum to the claimant's account, which would be in any event wasted if the appeal is granted and the judgment and the costs order are set aside.
Does that come down to an appeal, sorry, an application on the basis that whenever there's an appeal, there should be a stay of the judgment? Because it's always going to be inconvenience. If you don't get a stay, you have to pay. No stay, pay. But your argument is, if there's an appeal, there should be a stay, isn't it? You're not pointing to any, I don't think, you don't point to any circumstances beyond the fact that there's an appeal.
Yeah, I think so that I was just alluding to that there. We would say that the defendants would be significantly prejudiced if they would be required to pay such a significant sum of money, and in any event they'd just be wasted costs, and it wouldn't be in line with the overriding objective in any event, because it's such a big case. And obviously there's the expense, time and disruption to its business as well, in attempting to have to comply with the judgment and the costs order while the appeal is pending. So what
do you mean by that? If you've got the money, you write a check. If you've got assets, you realise them. What do you mean by the disruption to the business? Do you mean the fact that you'll be without $56 million or whatever amount it is? Is that what you mean?
Yeah.
Yep. Okay.
Yeah. So yeah, I think unless you have any.
And just going back to probably what's implicit, if you don't succeed in your application for permission to appeal, then your stay application can't succeed, can it?
No. I think you're quite right. I think, as you referenced at the beginning of my submission, if the substantive application for permission to appeal falls away, it is not successful, then the other applications would fall away. Yeah.
All right. Well, thank you. I think what I propose to do is to take a short break, convenience break, 15 minutes. That would take us, I think, to 47 minutes past the hour. We'll make it 50 minutes past the hour. So 10 to wherever you are.
Thank you.
All right. We'll take that short break. Thank you. Yes, thank you, Mr. Whitehead. I can see you there. We're ready then, Mr. Montague-Smith.
Thank you very much, Your Honour. I will try and be as efficient as my learned friend in bashing through the issues. The first issue then is this timing point. Where it's got to from my learned friend's submissions is that the document was sent to the court 7th of December. And
when you say it was sent to the court, I think it was, I thought it was electronically lodged on the e-system, wasn't it? Is that?
I think that's right. That's the mechanism. Yeah. Yes, correct.
Yeah.
Now, my learned friend has produced a document which is the invoice that was issued by the court. I think he suggested that there was delayed payment terms on that document. There isn't. It says payment immediate. And from an aside that was sent to him, that was given to him while he was making submissions, I heard my learned friend say, oh, it was a week later, was it? And that would explain the date that one sees on the appeal notice itself.
When the payment was made.
Which was when the payment was made, quite.
Yes.
Now, I'll take you to as many documents as you'd like me to. I do have this problem with my references, but I think I've got a reference to the appeal notice that's 2061, but that may be your 2057.
2061.
Maybe 2057 for you. And it should be just the appeal notice is what we're looking for.
Yeah, I have it.
Yeah, so you'll see the top right-hand corner is the issued date is the 18th of December.
Yes.
Now, so the question, as you quite rightly identified, is whether or not the date of filing is the date at which the document was lodged through the e-system, or the date on which it was sealed by the registry. And that question is answered in the case of Lila and later, which you will have at, I think, bundle 3243.
Yes, I have it.
Thank you. And so that was a decision of the Deputy Chief Justice, and you will see on page 3244 the facts of the case, and I'll just direct you to little 2 subparagraph B. The defendant filed an appeal notice to Justice Cook's order on 22 September 2019. Permission for appeal was refused by Justice Cook on 19th November 2019. The defendant acknowledged the limitation period for paying the filing fee at paragraph 3 of his grounds of appeal against judgment, dated 11 September 2019 and dated 13 October 2019, which states the appellant was arranging funds to file the appeal notice and obtaining transcripts of the proceedings and did not want to exceed the limitation period to file the notice of appeal. And then the C, you'll see on the second line, the defendant did not pay the filing fee at this time and eventually paid the fee on 2 January 2020, and then talks about proof of payment. And then you'll see paragraph 3, in my opinion, the notice was not complete in the absence of the filing fee and was therefore filed late, and says the application should be dismissed. And then the learned Deputy Chief Justice goes through the reasons why that is the position, and he explains that at paragraphs 4 and onwards, and in particular you'll see at paragraph 8, referring to the definition of a seal, he says at the second line, however, filing is also defined as in relation to a document means delivering it by post or otherwise to the registry. In my opinion, reference to a document in this definition relates to documents which do not require a seal, i.e. skeleton arguments. The process of sealing a document is undertaken by a court officer and is conditional upon a filing issue fee being paid. I therefore consider that RDC 3.15 applies. The process of filing was not undertaken until the fee was paid and the notice was sealed. Now, my learned friend took you to paragraph 11. Paragraph 11 is dealing with a different question. Paragraph 11 was a tit for tat complaint because the appeal under consideration by the Deputy Chief Justice was the appeal by the defendants. And so it looks like the defendants were saying, well, they were late in filing something as well. So that's irrelevant. But then, in a sense, you stop there, because if you look at paragraph 15, you'll see how the case was dealt with in this case. And effectively, I'm sorry, it's treated like an application for relief from sanctions. And so you'll see the application is dealt with at 16 and onwards. In my view, the defendant's application for an extension of time should be refused and so forth, and then goes through paragraph 17. The court should have regard to the test under RDC 449 for relief from sanctions. Now, what you heard this morning, and indeed actually that document that was provided, which was the evidence of the invoice and so forth, was that only came through this morning. And then in submissions, you were provided with some factual assertions by my learned friend about logistical difficulties with banking and so forth. And what you would need to see would be evidence of those matters so that you could understand whether or not the case warranted relief from sanctions. And I simply say this would not be a purely technical point.
Do I consider it in the absence of a formal application?
You do not. You do not. The only point I was going to make is that this is not just a formal point, because the way, certainly in England, the authorities look at these sorts of cases is they say, if you give relief from sanction, you are upsetting the present position. The present position is there's no appeal and there can be no appeal. And so if you give relief from sanctions, you deprive the claimant of that accrued benefit. And that is a weighty matter to be considered. So it's not just technical, and there are also questions about the due administration of justice and the finality of orders, which one would need to take into account. So I make those submissions not so that you can assess this case, but to make the point that if you were to consider taking that course, you would need a proper application, and it would need to be supported by evidence. And at this stage, my learned friend has rested on his position that he does not need an application. So we do say that is the end of it. I will obviously go on and deal with the points that are raised, because I've prepared to do so for the purposes of this hearing, and because we are all here, and would be ashamed to have to come back if it turns out I'm wrong. So, Your Honour, I was going to then move on and deal with what are described as 8 grounds for the first appeal. And the first 6 of those grounds relate to this case that there is an implied term, or there are various implied terms in the contract of what can broadly be described as good faith, but rationality, or so forth, the Braganza duty. And there are 3 ways in which my learned friend seeks to imply that sort of term in relation to the Landstone bond and the various other aspects. So I'll deal with the overarching points first, and then quickly see if there's anything else to pick up in relation to those 3. In relation, when we get to it, actually in relation to those 3, the distinguishing factor really is the question of breach, because you dealt with those separately. The principles of implication of terms are common across the 3. So your Honour's picked it up, but there are a number of points that are raised, firstly in the appeal that weren't raised at the hearing, and secondly in the skeleton today that weren't raised in the appeal. And some of the grounds aren't particularly pressed, but I will try and run through all of it, and we say there's nothing in any of them. On the question of implied terms, as you pointed out, everybody agrees Singapore law applies, but the defendant is now saying, well, there's a big difference between Singapore law and English law, and so it's not right to just look at the English law authorities. Just pausing there, and we'll come to it, you will see throughout the Singapore authorities reference to English case law. And so it's clearly right that if this case was being decided in Singapore, the Singapore courts would be looking to the English case law and any other Singapore case law that might be relevant. Now, it's not impossible that there would be a difference between the way that they approach things, but the burden is on the defendants to identify and support the principles of Singapore law, which they say give rise to these implied terms. And just starting briefly with the defence, I've got this at page 28, and you may have it at page 28 of the bundle as well. And I apologise, we're going from page 3000 odd to page 28, so maybe there's going to be a circle of death afflicting you shortly. But it's page 4 of the defence, my bundle, page 28.
Oh,
but
I've got it.
Ah, amazing. Paragraphs 9.2 to 9.4 are where they plead out these implied terms. and the basis on which they do so is the same in each case. So if you look under 9.2.3, for example, it said it's an implied term of each of the facility documents, and this is why, because it was so obvious as to go without saying, and or because it was necessary to give business efficacy to the same. And that's fundamentally, and then they plead out what the clause was. So the fundamental case is that what I would describe as the usual common law test for the implication of terms. It applies. Now, I've got your honour's point that is there a tension between the disjunctive or conjunctive approaches of the Singapore and English courts, and I'll come on to deal with that. But ultimately, assuming the broader test could be either, could be or, that is the test and that's the most favourable for the defendants. That's the law as summarised in the Marks and Spencer case, and it hasn't really changed over the course of time. And so we approached the case at the hearing below as if it, at the previous hearing, sorry, as if it was effectively being said that Singapore law embraces the decision made by the UK Supreme Court in Braganza. None of that had been really explained or set out by my learned friends. So we were backfilling their explanation and trying to deal with it. And that's the way in which it was presented to you. And of course, Braganza, as we know, was built on the prior cases that came before it, and in particular, the case of Socima. That then showed that, and Braganza explains when a contractual discretion will be subject to an implied term and why that is the case. And you can use that logic to understand, when you're looking at any given contract, whether or not that sort of duty really will be implied. And my learned friend, as we know, says that English law is not a good reference point for the law of Singapore in this area. But dealing first with the grounds in the order that they're put, I'll come back to what he says the differences are. Essentially, he has prior points. He's got 2 prior points. And I think it's probably worth just going through the appeal skeleton briefly to look at this. 2063 is where I'd ask you to go to, I think. And it's going to be paragraph 15 to 17 I'm looking at here of his skeleton. So this is all under the heading burden of proof wrongly placed on the defendants. But the first few paragraphs, which haven't been pressed today, are 15 to 17, which complain that documents were not served with the pleadings. We explain why that's misconceived. You don't need to serve documents with your pleadings. But again, that doesn't appear to be pressed today. The main point arises at 18 to 24, which suggests you reverse the burden of proof. So my learned friend says, in effect, the substance of the thrust of what he says is that he should be entitled to plead out the implied terms, say Singapore law applies, and it's different, and that should be enough to carry him to trial. So fundamentally, he's proposing some sort of investigative process by the courts, which of course is not how this court operates. And your Honour has the point. My learned friend needs to explain, and needed to explain, what he says Singapore law is, and he needs to support that. Now, the primary way that you would normally support that in this court would be by submission. But my learned friend in his second ground says, well, that's the wrong approach, and this is the sort of wrong approach to law. It's all fact argument, which is then on the next page, and you'll see that from paragraphs 25 onwards. And he refers to the case of Fidel and Felicia, which we did give you some supplementary submissions on. I mean, actually, what he says is that you applied the wrong law. Well, of course you didn't. You identified what Singapore law was by going to the English cases, because nobody had said that Singapore took any kind of different approach. And indeed, I will show you they do not. So just pausing there, though, what my learned friend's position is, well, you can't do it by submission. You needed to do it by expert evidence. Well, if that is right, if expert evidence was required, then he should have produced it. But actually, you don't need expert evidence. Your approach was absolutely correct. Now, and then that is the effect of Fidel and Felicia. Now, my learned friend says Fidel and Felicia does not apply in this case. And you can see at paragraph 32 why he says that. He says it doesn't apply because it was about the recognition of an arbitration award. That's obviously not correct. And again, I can just show you one passage. Fidel and Felicia is in the bundle, and I'm going to hazard 2645. And we're looking for paragraph 49. Paragraph 49, in my judgment, neither the English approach nor the Talim approach, and unless you'd like me to, I won't go back over that, is appropriate for the DIFC courts. Rather, the DIFC courts should adopt the approach of accepting all submissions on non-DIFC UA law as part of legal submissions, as is usually done in international arbitration. Now, there is a discretion of case management to permit foreign law or non-DIFC law by expert evidence. That does happen. But if you want it to happen, you have to make an application for it. And it can happen on hearings such as this, if necessary. But ultimately, until someone tells you, the court, what are the principles you're seeking to prove? What do you say the differences are? And the court, in its control of expert evidence, is never going to give that permission. So you would always, in any event, if permission to adduce expert evidence had been presented and permitted, you would need to see that expert evidence. And in practice, what would that look like? That would look like a report from a Singapore lawyer, and it would be supported by case law and possibly legislation. And so there's no reason why the defendants could not have produced that case law and that legislation. And indeed, we now know, because they've produced it in response to this, in support of this hearing, that they have engaged Singapore lawyers in Singapore to deal with what they describe as a very similar case. So they clearly have access to Singapore legal input, which begs the question, why on earth they didn't produce these materials in the first place. But either way, grounds 1 and 2 are effectively prior points focusing on the way in which these decisions were reached. And there is no real prospect of any of that criticism succeeding. It's an entirely orthodox approach to determining these sorts of issues. So then we come to ground 3, and the arguments that Singapore law is somehow materially different from UK law on this. Now, the first point, just a prior point that we make, is that for the skeleton argument for today, and I don't know whether you've got that separately, it is also in the bundle, I think.
I do.
Paragraph 28, they criticise paragraph 90 of Your Honour's judgment, where you took no judicial notice of the fact that Singapore contract law is based on the common law of England and Wales. They say this is respectfully an incorrect approach, which shall be demonstrated. Now, it is very difficult to see how they are able to make that submission for 2 reasons. Firstly, there is legislation in place which preserves the English common law in Singapore. You will find that, I think, at page 3228 of the bundle.
Sorry, what page was it?
I think it's 3228. 3228. and that is the Application of English Law Act 1993, which is, by the way, an act to declare the extent to which English law is applicable in Singapore and for the purpose connected with therewith. Now, Article 3, Section 3, and its little one, the common law of England, including the principles and rules of equity, so far as it was part of the law of Singapore immediately before 12 November 1993, continues to be part of the law of Singapore. So it's preserving, I think, post the sort of process of independence, preserving the status of the common law. But in practice, you can see it in the cases as well. And if Your Honour has my skeleton arguments.
And subsection 2 goes further.
Yes, I read subsection 2 to be making the point that the common law can develop separately in Singapore.
Sure.
So it's not mandating.
As it does in other common law countries.
Yeah, quite. Exactly. And it's not unusual to see these sorts of provisions I mean, we even have it in the DIFC in relation to the trust law, for example.
Yes.
But of course, it's right that each of those individual countries will develop the common law. But my point is simply, my learned friend makes the submission, contract law in Singapore is not based on the common law. Answer, well, actually it is. It may develop from there, but actually it clearly is. And we can see that in the Singapore cases that my learned friend relies on. Now, we've picked up all of the ones that were relied on in the appeal skeleton. There is one more, which is this Deutsche Bank case, which I will deal with afterwards. But I've collected them in paragraph 23 of my skeleton arguments. And that there are 4 cases relied on, and then we've got this new one. Now, there is this discrete complaint, and it's slightly difficult to see how it all fits together, but there is a discrete complaint that none of these cases, it is said, refers to Marks and Spencer, and none of them refers to the UBS case. That is a pretty surprising submission, because the UBS case was decided in 2018. As you cast your eye down those 4 cases, you will see that only Lehman was decided in 2018. And my understanding, although I haven't double checked this, is that it was decided before UBS. They're not very surprising that none of those cases refers to the UBS case. And only one of these cases is decided after Marks and Spencer, and that is the Lehman case. And because Marks and Spencer was decided in 2015. So making a submission, well, the leading case, Semcor, on the implication of terms, doesn't refer to Marks and Spencer, is a problematic submission, because the implication is that it could when Marks and Spencer came later. But actually, and again, Your Honour has these points. You're clearly on top of all of this. We know from Semcor that the approach that was ultimately taken in Marks and Spencer is consistent with the Singapore law position, or the nuance. I would describe it as something of a detour that was that followed in the wake of the Belize case and Lord Hoffman's conclusions in that.
Yes, I don't know that it's necessary, but I must have had some time to do this. I found an article called "The Limits of Contractual Discretion" by Ken Wei Ong, reported 2021-33 SACLJ, in which starting, that's at 919, and at 935 at paragraph 33, the author writes, quotes, parenthetically, it is observed that in England, where the threshold for the implication of terms is arguably lower than that imposed by the Semcor framework, such a term would appear to be readily implied, end of quote. I don't know that the author explains that, but as I was putting to Mr. Whitehead, if you just look at the test, the Semcor test, which has those 3 steps, all of which must be met, would seem to be arguably a stricter test than the what's explained in Marks and Spencer's, but I don't know that it makes a lot of difference in this case.
Quite. And we had found the same article, but we didn't wish to burden you with too much. And if we were to go forward with this,
Yeah.
then no doubt that would feature in the appeal. But Your Honour has precisely the point. This only matters if you were applying too narrow a test to the question
Yes.
of implication of terms. Now,
we
say actually, in practice, it doesn't make much difference. In saying that, we rely on some of the English authority to that effect. But where this comes out, this particular issue comes out, is that my learned friend says, well, you applied an 8-part test derived from English law, but there's only a 3-part test in Singapore. That is not, in my submission, a terribly fair summary of quite what you were doing. So the relevant passage of your judgment is at 1983.
What paragraph was it, do you know?
It is paragraph 125.
Yes.
So one is a sort of joined up combination of the 2 tests, business efficacy and obviousness, officious bystander. And then 2 identifies the particular potential distinction with Singapore law, and then says, however, it will be rare or unusual case where one but not the other is satisfied. And that's, I think, why ultimately it doesn't make any difference either way.
Yeah.
And then the rest of this is simply further gloss on how that test is approached. It's not identifying a different test than the one that my own friend applies in SEMCOR. So, for example, it explains what business efficacy test is. It explains what the obviousness test is. It makes the point at 5 that a term will not be implied if it's inconsistent with an express term of the contract, and there are various other aspects of it. Now, if my learned friend wanted to say that, for example, was not a feature of Singapore law, that would be a pretty bold submission, then he would need to provide you with support for that. In reality, the Singapore court takes precisely the same position. It takes the position that there is freedom of contract, and the parties can agree that there will be no implied duty of good faith. The parties can agree that they have absolute discretion over the way in which they exercise contractual rights. There's nothing wrong with that. It's just about making sure that that is what they have in fact done, which is all about the interpretation of the contract and understanding then what if anything is missing. But in the case of and we'll come back to the question of the exclusion of implied terms, it is perfectly open to the parties to exclude implied terms. And if that is the effect of what they have done, then all of this falls away. Now, as to so that's the submission that the Marks and Spencer is inconsistent. And in fact, Marks and Spencer refers to SEMCOR. You may have seen that.
Yes, I did see that.
So that, if you need it, is at page 2935, paragraph 24. At the end of that paragraph.
What page is it?
Sorry, 2935. Perhaps while we're here, we might as well look at it.
Yes.
This is on the Belize point.
Yes. Yes. And
so
what paragraph?
Paragraph 24
Yes.
is the court was dealing with the Belize detour, which I think I've now named it. And at the end, you will see the last paragraph, last sentence, sorry, at C down the side. The Singapore Court of Appeal were, in my view, right to hold that the law governing the circumstances in which a term will be implied into a contract remains unchanged following the Belize Telecom case. So there might well, between these two cases, Belize on the one hand, which although that was a Privy Council decision, and on the other hand, the Marks and Spencer case, there might well have been an argument that there is a material difference in the approach of these two courts to the way in which they approach the question of implying terms. But all of that was wiped away with Marks and Spencer. Of course, in Marks and Spencer, the UK Supreme Court said, well, there was never really any difference. It was all a big misunderstanding. Whereas perhaps the Singapore court was a bit more blunt about it. But there we are.
Yes.
So that's Marks and Spencer, but then the UBS case, as you'll recall, is simply an application to a particular contract of the principles at play in Braganza, which is a very distinct kind of implied term, which has developed through Socoma into Braganza and then subsequently with following cases. Now, it's quite clear that the Braganza principles are part of Singapore law. And the Braganza UK Supreme Court case itself is the sort of fountain point of that now. But the cases in Singapore, of the ones that are identified, as I mentioned, only the Lehman case, the LEIM, Lehman I call it, case, was decided after Braganza. So Braganza was 2015, MJ International came in 2010. Lehman came, I think, in 2015, and Edwards came prior to that as well. So what I was going to do was just run you briefly through the 5 cases and tell you why we say actually there's no material difference here. So the discussion, and again, I think it's 2837 for you, which we're looking at MGA now.
Ah, yes.
Just taking them in the order that I've got them in my skeleton at paragraph 23.
Yes.
So we've got at the bottom of the page, if you've got paragraph 103, if that's appearing, apologize if not. Good.
No, I've got it.
Excellent. And so what you see is that the discussion of a contractual discretion is not usually as unfettered as Ms. Tan would like this court to believe, and then says the authorities on contractual discretion recognise that there is a corresponding expectation that the discretion would be exercised fairly and rationally, and then says guidance can be drawn from Hawkaluk, which is an English case from 2005, and then goes through the English cases. So you'll see at paragraph 104, in particular, there is reference to the Socoma decision, which, as Your Honour has explained in your judgment, was the most significant precursor to the Braganza case. So in that case, as the court goes through these decisions, what the court is doing is down to paragraph 106, is referring to and summarising the impact of the English decisions which led to Braganza. So again, there's no difference in the principles here at all. This is MGA. The Lehman case, or L-E-I-M-A-N, Lehman perhaps, Lehman and Noble Resources case, comes after Braganza, and that actually applies Braganza. So you see that at page 3000, I believe. And we should be looking for paragraph 112 of this.
Yes, I have it.
Super, thank you. And so you'll see paragraph 112 dealing with the question of contractual discretion. It is now established that where one party to a contract is given the power to exercise the discretion, the courts will seek to ensure that such contractual powers are not abused by applying a term as to the manner in which such powers may be exercised. Such a term may vary according to the terms of the contract and the context in which the decision-making power is given, and then refers in terms to Braganza. And that is just confirming that this is the source of all of this is Braganza. Now, my learned friend relies in particular on the final, the next sentence, I think, of this paragraph. In the other words, in the absence of very clear language to the contrary, a contractual discretion must be exercised in good faith and not arbitrarily or capriciously. But that also, so my learned friend relies in particular on that. And actually in his appeal skeleton, he says that's the difference between English law and Singapore law, because this is the way that Singapore law approaches it. But actually, what he's relying on is simply a summary of the effect of the English decisions. There's no source other than English case law or UK case law in that paragraph. He then goes on to say these
seems to be quoting the British Telefonica case, is it?
Yes, which predated the Braganza case, which slightly reset things. But that is a précis. It's not a rule of law. It's not a statute. It needs to be applied in each case by reference to the principles adopted in England, effectively. And then paragraph 113 says that these principles have been accepted by the local courts and refers to MGA. So that clarifies that there is clearly no inconsistency between the English position or the UK position as described in Braganza and the Singapore position both before and after Braganza. And also, this tells us nothing about, and this is critical, and one point that my learned friend just hasn't addressed at all. It tells us nothing about what amounts to a contractual discretion. I'll come back to this perhaps, but for example, parties to contracts have choices that are not contractual discretions. Not every choice under a contract is a contractual discretion. So if I have a right to renew a contract, that's ordinarily an absolute right. If I have a right to terminate that arises because there's been a breach, there's been a default, or simply because through an effluxion of time, that's not ordinarily a contractual discretion in the appropriate sense. The point about Braganza is that you have to interpret the contract and understand whether or not that decision is being made purely selfishly, or whether the parties are agreeing that it is a decision that's being made on behalf of everyone, and therefore you need to make it fairly and not arbitrarily. The next case, and this is one that's been referred to a few times because it comes up in the Deutsche Bank case, is the Edwards and Australia and New Zealand Banking Group. It may be called Glen because the Glen comes at the end, but I think the Glen is the second Christian name, if I can put it like that, of the claimant, and so actually it's Edwards, Mr. Edwards,
yeah,
and then the names follow. So I'll call it Edwards. But again, that also adopts the English principles. You should find it at 2302. Paragraph 100 we're looking for. So just starting with paragraph 99, which is what you were taken to, you'll see second sentence. Firstly, the judge agrees that ANZ had the contractual right to assess the security using its sole discretion, and then says, however, a point that was not canvassed before me was whether this discretion was unfettered. So it's not an argued position that's been taken in this case. It's just something the judge has come up with, which is fairly fine in Singapore, but wouldn't normally be an appropriate course in this court. Normally the parties should have the opportunity to deal with it. But to answer the question, where does he turn? He turns to Lewison. Who is Lewison? Lewison is an English textbook, Lord Justice Lewison, as he now is. And it's a contract on English contract law.
Interpretation, isn't it?
On the interpretation of contracts, precisely. It does deal with implication. So Belize,
Yeah.
the Belize detour is not relevant to that. For paragraph 100, then he turns to MGA, which we've looked at ourselves, and below MGA he refers to SOCOMA. And as you know, this case was also before Braganza, so he doesn't get to Braganza. And then he deals with, on the next page, cases like JML Direct, Hawkerlook, which we've already seen appearing, and then underneath that you'll see a series of other English cases. And then concludes that on the terms of that contract, there was not an untrammeled discretion. Now, we don't know. I mean, we can look at the terms of that contract and we could do an analysis if we wanted to, but nobody said, well, the features of that contract are so materially identical to the features of our contract that we need to reassess the whole thing, and this new case changes everything. And we would say that ultimately what we get from this are principles, not conclusions. The principles are precisely the same. The conclusions in that case turned on that contract. But on the principles, there's no difference whatsoever. And that's also the position we say in relation to this most recent case that's been produced, which is the Deutsche Bank case. Now, the relevant passage of that, I think you have it at page 2399. And what happened in that case is that the judge found that there was a triable issue, that the contract in that case had implied terms of this sort. Now, preface this, that was very much an aside, because as you can see from the previous paragraph, the judge had already reached a view that there were other triable issues that justified a trial. So then this was dealt with very briefly. Different court systems take different approaches to summary judgment applications. In this court, the approach of the court usually, and it's up to the discretion of the judge hearing the application, but the approach of the court usually is that in this court, the court will decide issues of law, which don't depend on disputed factual issues. And generally speaking, a decision on the meaning of a contract is an issue of law. Now, some judges will say, well, it's too complicated for me, I'm going to put it off to trial. Some judges will say, no, I'm going to grasp the nettle now. And the extent to which they go into that investigation is a question for the individual judge. So that is absolutely an exercise of discretion. The fact that in that court, the Singapore court decided it was going to leave those issues over to trial does not mean that this court needs to do the same in relation to all Singapore law decisions on the meaning of contracts. Now, one thing I would note from this passage in paragraph 21 is that it seems to have been understood in Singapore that the effect of your decision, you get this really from the other part of the case, but the effect of your decision was that you were laying down some principle of Singapore law that in assessing the adequacy of security, there can never be an implied term of this sort. But of course, you weren't going that far. You weren't pronouncing on Singapore law in general terms. You were looking at the terms of this particular contract and saying on the terms of this contract, that's an absolute discretion, not a fettered discretion. And for various reasons, some of which are subject of debate today and some of which have been left rather behind. But essentially, what you found, and I mean, ultimately what you've got then is you've got a decision from the Singapore court saying in that case, the issues with that contract, the issues are such that I think it should go off to trial. And in our case, we've got a different contract where you've looked at it and you've said, well, applying the principles, and rightly the correct principles, there's no scope to imply the term today in this contract. So that decision, we would say, can give you no pause at all. It doesn't engage with our contract. It doesn't displace any of the principles that you've relied on. And there's no attempt really to engage with that, with the way in which you decided it. And as I mentioned, it doesn't tell you anything about whether or not these were discretions at all. Your Honour found, in particular, just dealing with this, just take as one example, the central right to recall the loan and to refuse to lend. So well, I've got it pages 2004 of the bundle to 2005. You reached the conclusion that that was not a discretion at all. And I mean, just pausing there, that would be a very strange argument to suggest that you can't have a loan that is uncommitted. An uncommitted loan is a well-known principle. It's this is the shape of what we will lend, but we're not going to lend until we're satisfied on each occasion that it's the correct amount. That's the effect of what this is. Now, if we're right about that, if you're right about that, there was no obligation to lend, and my own friend doesn't actually grapple with that. All this stuff about Braganza duties, this case, MGA case, it's all irrelevant because it all applies only to discretions, not to absolute rights. And if we get that far on lending, then everything else falls away, because the case on the Landstone bond, for example, is that the bond was undervalued. And that meant that more lending should have been advanced against that bond. That's the thrust of what was being complained about. We didn't get enough cash and that caused us loss. That's the substance of the complaint. But if there's no obligation to make any more lending, then the fact of the question of how we valued the collateral is just neither here nor there. It doesn't lead to any loss. So that central core conclusion, it was an uncommitted loan, dispenses with all of these arguments, we say. And the same is true for the refinancing points. The issue there was whether the bank was somehow obliged to allow the borrower to withdraw all of the collateral and hand it over to another bank before repaying the loan. If you recall, we went through those documents in quite a lot of detail. I mean, that in itself is a pretty extreme case anyway. I've lent you whatever it was at that point, say it's $75 million. I've got $25 million worth of your collateral, and what you want to do is switch it to another bank and then pay me back, leaving me completely completely exposed for that intervening period. It's not a credible argument. And the case about failing to load the full facility, that's the third sort of target for all of this. That is straightforwardly an allegation of failure to lend. So that's, we say, it's a substantial hole in the appeal. Similarly, there's no attempt to grapple with Your Honour's fundamental findings about business efficacy, which overlay all of the Braganza analysis. And it's the essence of the test that's asserted in their defence. The effect of Braganza, nobody could say the effect of Braganza is that every single decision that's made by a contractual party has to be made subject to this duty. That there's no principle that every contract in English law, or indeed Singapore law, is subject to a duty of good faith. That's the logical consequence of where that goes. That's not the law. Nobody can say that is the law. That would be absolutely wrong. How do you work out which duties are and which duties are not subject to these implied terms? You have to resort to the business efficacy test and the general interpretation principles of contracts. again, we say the appeal is fundamentally incomplete in that way. And then it remains fundamentally incomplete, we say, in two other important ways. The first is about the exclusion of implied terms. Come back to that in a moment, but just to summarize. And the second is the breach issue. Now, you were shown some material in relation to that. In fact, there are no submissions on this appeal in relation to two of the breaches that were alleged, and your findings that there were no such breach. There is one exception to that, but actually on analysis, it doesn't take you anywhere. So I'll go through all of that relatively swiftly. In relation to the implied terms, just to remind you, Your Honour, what you decided and to show you the term itself, it's page 1192. Sorry, 1992. And it's paragraph 159. The parties 1191 is 159 at the bottom, and then you'll see the actual term at the top right on page 1992. And so this is the relevant term. You further agree that subject to any duties or obligations imposed by mandatory applicable law, which the bank cannot derogate from, the bank owes no other duties or obligations to you save as expressly set out herein, and that no implied duties or obligations shall be imposed on the bank under or by reason of this agreement. And so you make the point, if we go to page 2004, paragraph 250, the parties expressly agreed that no terms are to be implied into the facility agreement. So if that is the meaning of that clause, there are no implied terms, there's nothing wrong with that. There's freedom of contract. It's said in one of the cases, well, if it turns out that that really amounts to an exclusion clause, then you can refer to statutes equivalent to the Unfair Contract Terms Act. And we do have those equivalents in the DIFC, and I'm sure they have them in Singapore, but nobody's made out that case. Nobody's asserted anything like that. And actually, it doesn't work for this sort of implied term. Why not? Because the implied term is not imposed by mandatory law. It's just a question of what the intent of the parties is in signing up to those agreements. And if the intent of the parties is that there is no implied duty, then there's nothing to stop them from agreeing to that. Now, on this issue, my learned friend referred you to, again, another new case called, I have it as Yap Hon, but I'm probably saying that wrong. And what my learned friend told you was that the clause in that case was similar to the one in this case, but it wasn't. If we look at page 3, I've got it 3136. And you should have the clause on that page at the bottom, at clause 18. And it says this agreement embodies the entire understanding of the parties, and there are no provisions, terms, conditions.
Am I the right page 3136?
I hope so. So what you'd be looking at is a passage from the case.
Bottom of it, yeah.
And it's got a paragraph 8 in the middle of the page, and at the bottom, and so paragraph 8 sets out the salient clauses, and the last one is clause 18. Yeah. And what was said was that this clause was materially the same as our clause, which I've shown you, but it isn't, because this one says this agreement embodies the entire understanding of the parties, and there are no provisions, terms, conditions, or obligations, oral or written, express or implied, other than those contained herein. So what you've got there is an agreement that all of the express and implied terms are in this agreement, and that's effectively how that was decided. So if you go down, please, to page 3144. Sorry, I'm struggling a bit because I've got these different paragraph numbers. Yes. You see paragraph 28, firstly, the last two sentences of this, starting from the third line from the bottom. Much will, as we have seen, depend on the precise language of the entire agreement clause concerned, as well as the nature of the implied terms that are relied on. However, we'll endeavour to set out some guidelines on this issue. And then ultimately, they find, so paragraph 29, they refer back to clause 18 and they repeat it. In paragraph 30, you'll see why they decided against it on this, that it didn't exclude implied terms on this case. We find the appellant's argument to the effect that clause 18 itself contemplates the existence of implied terms persuasive. Indeed, that clause refers expressly to implied terms, as the italicized words in the clause clearly demonstrate. This is in fact sufficient to dispose of the first main issue in the present appeal. So the point there was that it wasn't clear enough from that clause. And one can see there's ambiguity potentially in that clause. On the one hand, one party was saying, well, when we say there are no provisions express or implied other than those contained herein, what is meant there was there are no provisions express or implied other than those expressly contained herein. Whereas the other party was saying, no, all they're saying is this is the document, complete with express and implied terms. There are no other documents, there are no other agreements, oral or otherwise. So when we go back to what our clause says, and again, it's 1992. It does it 1992. The bank owes no other duties or obligations to you, save as expressly set out herein. And there are no implied duties or obligations that shall be imposed. So the point that comes out of that case, Hon, is not that you cannot exclude implied terms. It's just you have to be clear that that is what you are doing. And they say that in terms at paragraph 32 of their judgment, which is back where we were looking. We won't go back to it unless you need to, but it's 3144. So in order to persuade Your Honour that there was a real prospect of success on this appeal, on this part of the appeal, which is most of it, frankly, my learned friend would need to be showing you that clause and explaining to you why that didn't mean what it plainly means, which is that only the express terms apply and there are no implied terms at all. That's legally permissible. You just have to be clear about it. That clause is clear, as Your Honour has found. So that's the first problem. That's the next problem. And then the next problem, the next hole in the case is the case about breach. Now, Your Honour will recall that in relation to each of the allegations of breach, you went through and considered, well, okay, if there is a duty, have I seen enough to say there's a real case that they've been breached? And the answer in each case was no. I can give you the references to where you've made those decisions if you like, or I can take you to them, or we can leave them as read.
You can give me the references, please.
Certainly. So it's firstly in relation to the Landstone bond, you address it in the judgment of paragraphs 163 to 180, and that's at page 1993 of the bundle.
Yes.
In relation to the decision on refinancing, you find that at paragraphs 192 to 246. That starts on page 1996. And in relation to the alleged failure to load the facility, That's at paragraphs 276 to 281 and page 2009 of the bundle. What I will show you is what my learned friend says in his appeal. You've been shown some of this, but not all of it, and is just being a bit thorough about it, I think. If we go to page 2069, we get the skeleton. And you will see the allegation in relation to the Landstone bond starts at paragraph 58. And the only point taken, there's only, what, 4 paragraphs there. The only point taken there is that there is no duty. And obviously it's right. If you decided that there was no duty and that's been challenged, but there's nothing there to engage with your reasoning that comes next. Well, even if there was a duty, there's been no breach. Paragraphs 62 to 66 deal with refinancing. And again, quick scan of that, you will see that it's all about wrong on law. There should have been an implied term. Nothing on breach at all. And then finally, the failure to load the facility. Now, this is at paragraphs 67 to 73. Now, this is where my learned friend Skeleton does say there was evidence of a breach. And that's at paragraph 68 to 70. And what he says, if you look at paragraph 69, is that the evidence of the breach comes in a particular place. And that is in Dr. Hayder's second witness statement, paragraphs 329 to 340. So now we have to go to paragraphs 329 to 340 of Dr. Hayder's statement, which you'll find at page 694. I hope. So we're looking for paragraphs 3.29.
Yes.
So the first 3.29, you'll see what is said there, simply that the facility was not made available. There is an additional gloss. You'll see at the end of that paragraph, second to last line up, it says, despite the assurances from the claimant that $5 million would be made available. Now, that's a reference to document DA241. That document is at page 746 of the bundle. And none of this is argued out, but let's humor it for a moment. This is the email. And it says, sincere apologies for the delay. It should be available before tomorrow's US market open. It's not assuring them that it will be, but in any event, there is no case that any particular loss flowed or any particular legal consequence flowed from those assurances. And as to the question of, it sheds no light on the question of whether or not, assuming the bank had to act rationally, that there was a breach when they said, no, we're not going to load those further limits until we are convinced of the security that we have and get more security in. So if we go back to where we were, which is page, 694. We looked at 329, now we look at 3.30. And when you read that, you will see that essentially it just states that the bank demanded additional security. And the rest, which comes after, you'll recall that what was referred to in the skeleton argument went all the way up to 3.40, but the rest of these passages simply deal with what they say were the consequences of not getting the money. So this is not evidence of breach of a duty of good faith or breach of a duty of rationality. There isn't even any explanation of why those decisions were said to be irrational, why what was done, why it was irrational not to do what the defendants say should have been done. There was no evidence that the security requirements being imposed by the bank were unreasonable, even if they had to be reasonable in making those determinations. Now, what you have in the latest skeleton argument for today and what you had in oral submission for today doesn't go into this sort of thing. What you have instead is a general submission, which is essentially that once the duty is established, the question of breach is just a matter of fact, which has to go off for trial. But of course, it doesn't work like that. What is required to demonstrate a real prospect of success is A, the allegations and the explanation, the factual allegations and the explanation of why that amounts to a breach of duty of rationality, and B, at least something evidential to support those factual assertions. And we have none of that at all. And then the final point on these cluster of grounds is the point that Your Honour raised. We haven't majored on it, but it's the no set-off decision. That doesn't dispense with the appeal, but it does dispense with any appeal against the judgment, if I can put it like that. It effectively would be about what would be left would be the counterclaim, even if my learned friend was right on all the rest of this. There's a no set-off clause. There's nothing wrong with no set-off clauses. The reference to that in your judgment is at page 1981 of the bundle, paragraph 114 and following. So again, there's no engagement with any of that. But fundamentally, we do say actually even the counterclaim is hopeless for the reasons you gave in the judgment, and nothing that has been said in advance of this hearing displaces any of that. There is no material difference between the principles applied by the Singapore courts and the English courts. So the basis on which you approach the question, is this contract subject to these implied terms, is precisely the same exercise that the Singapore courts would have adopted. And the fact that in another case involving a different contract, the Singapore court has not felt able to decide that issue, which we would call an issue of law, on a summary basis, shouldn't deter you from doing so. And anyway, that's a matter of discretion. So that's the substantive points about the claim and under the loan agreements. Then there's ground 7, which deals with the witnessing requirement. So Your Honour will recall that you looked at this issue very carefully, and we've all put in many submissions prior to the decision on that. Yeah. The short point that Your Honour saw was that the requirements of English law, the formal requirements of witnessing deeds under English law arise under statute, not at common law. And there's no equivalent statute in Singapore. There's no engagement with that at all in my learned friends' submissions. Instead, what is said is, firstly, it's said rather softly in the skeleton that the evidence of Mr. Sani was challenged. Show you that. It's at page 2072 of the bundle. Paragraph 75. This is the skeleton argument. This is the appeal skeleton. And paragraph 75, the evidence of Mr. Sani was challenged on the basis that since he admitted he did not sign in the presence of the executor of the guarantee, and calls into question whether the guarantee was properly executed. So, in other words, the legal consequences of his presence were challenged, of his evidence were challenged, but the facts which he states were not. And so the fact that he actually witnessed the deed being signed is not subject of any challenge. There's no evidence whatsoever to challenge that. The references to that are at page 683, and you've dealt with all of this in your judgment, but it's worth just making it, now that we're here, clear again. Page 683 is Mr. Sani's statement. Is that right?
It hasn't. I'm still looking at a spinning wheel.
It may be 687. This one.
What
the missing?
paragraphs?
There's only 4 paragraphs in the document. It's paragraph 3, and he just says, "I attended the office on the date," and so on. And then the response to that came on page, but I've got it down as 707. May be accurate. The 4 missing pages obviously are critical, and they come somewhere in the middle of the bundle. But so I've got it at 707. In any event, it's Dr. Hyder's second witness statement, and it's paragraph 4.6. And he says, "I don't know when he added the signature to the deed of guarantee, because he hadn't seen him sign it, so he can't confirm it. But there's no dispute that he was there, and they would know. Of course, they would know. They were in the meeting. That's something they would know." So 2 points are made on the witnessing, and whether witnessing was a requirement and whether the formalities of witnessing are required. The first, what's said in the skeleton, is that the case of Lim Ji Peng or Xie Ping was about sealing, not about signing. So it's about the requirements for sealing, not about the requirements for signing. But that's irrelevant, because the point is that the formalities for signing a deed are derived from the common law, not from statute. That's the only point you need to take from that. So there remains no case before you about how these witness requirements arise in law. What you have instead is this new point, not taken below, that the obligation comes from the deed itself. So I think it's 30. I've got it at 303. Just to remind you of these documents.
So you say 303?
Well, yeah, this is the end of the deed. 303 is
yes,
one of the blank signature pages.
Yeah.
And you'll see that is a document, when it comes up, which is for guarantors who are corporations. And you'll see there, which this one was not. This one was an individual. But just note, just for your notes, so you give some context. Footnote 4. You see about 2/3 of the way down the page, it says witness, and then there's a little footnote 4. And then footnote 4 says, applicable only if execution before a witness is a requirement under 1, the laws of incorporation of the corporation, or 2, the constitution of the corporation. So that's sort of contingent requirement. And then on page 304 is the signature sheet for individuals. And it's got there footnote 6 in the presence of, and it says execution before witness is mandatory. And so the question becomes, well, what's the effect of those words? Are they a term of the contract? No. But even if they were, imagine they were a term of the contract. Who are they imposing the obligation on? They're imposing the obligation on the signatory to the favour of the bank. But even there, all it's requiring is signature in front of a witness, which we know happened. It's not importing the English statutory regime for witnessing a deed, number one. And number two, it wouldn't have the same consequences as the English statutory regime if that was not complied with, because the English statutory regime makes the document void. It doesn't allow it to become a deed. It's not void as a whole, because then there's the contractual side of things. It allows it to become a deed, but it's the fact that there's some obligation in a contract that it be signed in that way doesn't mean that the contract is void, or the instrument is void if it's not complied with. So it doesn't go anywhere. And then the other point here, of course, is that your honour found that if the guarantee didn't operate as a deed, it operated as a contract. I haven't heard anything about that. So this is completely academic, because there's no appeal against the contractual basis on which they would be liable. That's ground 7, which is witnessing. Ground 8 is about interest. We've really heard very little about that. Your Honour will recall the point here, that the contract contains 2 interest rates, and the argument is they conflict. No, they don't. One applies during the contract, and the other applies if there are overdue sums. And they are cumulative in that event, albeit the bank only charged the 5%. It only charged, the default interest. It didn't apply the both of them cumulatively. So actually, the defendants were undercharged interest in default, as Your Honour found. Nothing that's been said in any of the documents, and nothing very much has been said today at all, would displace any of that. And that is it for the grounds on the substantive appeal. On the costs appeal, Your Honour, the timing issue does not apply, as we understand it, to the costs appeal, so they're entitled to ask permission in relation to that. In our skeleton argument, we remind Your Honour of the approach of the Court of Appeal to costs decisions and challenges thereto. We've set that out in paragraph 47 of our skeleton. The test is what is required. Firstly, it's an exceptional course for the Court of Appeal to interfere with the discretion in determining costs. And secondly, it will only be justified where there is either a substantial departure from due and proper process. Nobody is suggesting that in this case. Everybody had a proper opportunity to argue the points. And or B, an error in principle, which is likely to have caused significant prejudice to the party seeking permission to appeal. That's the Melody and Melance case from the Court of Appeal. We've cited that in paragraph 47. So costs appeals are discouraged because they're very much for the benefit of the, under the purview of the first instance judge, who has heard everything and has a much better grasp of all of it. So the 3 grounds that are asserted, apart from the substance of the appeal, just dealing with that, we would agree that the costs below would be revisited if the appeal advanced and succeeded.
Yeah.
We don't necessarily agree that they would follow the event, because there's been quite a lot advanced subsequently, and if anything changed, it might well be that. But the 3 arguments that are run are that quite apart from the substantive appeal, it was wrong. Is firstly, you said you found that the claimant had succeeded on its principal claim. We find the submission in relation to this very difficult to understand. Our client sought judgment for $55 million on 2 different bases. One was in debt, and one was for misrepresentation in arranging the loans in the first place. That was an additional basis for the claim. So you can see that if we go to page 23, this is the particulars of claim. Paragraph 65. Further, alternatively, the claimant has suffered loss and damage as a result of the misrepresentation as to the bonds, in that it was induced to provide the facilities without the effective security, which was to be provided by the bonds. So the loss is providing the loans. So if we get the loans back and are made whole in relation to that, then that is it. That's the remedy that we've got. There's nothing more to claim for. Now, we needed that. Why? Because if it was being asserted successfully, and it was successfully asserted, that the guarantee failed, we would still want to be able to make a claim against the individual on the basis that he was responsible for the misrepresentations. The misrepresentation is not a separate and distinct claim for remedies. It is a claim that is made to support the remedy of a payment of $50 million plus. It might lead to, if that basis was the one that succeeded rather than the debt claim basis, it might lead to differences in, for example, interest. That's quite possible. But the substantive amount that we're left out of pocket is really what we're trying to get back. So the principal claim was to recover that 50 million, and we recovered it. Or we haven't recovered it, we got a judgment for it. And recovery may, it sounds, be something separate. So your Honour awarded the costs of the claim, save for the cost of the misrep claim, and I can quite understand why you did that. We argued for a different conclusion, and you found against us, and that's fine. But the point is that that is entirely within your discretion. It doesn't amount to a matter of a question of principle or an error of principle. There's no arguable error of principle. Your conclusion that this was the principal claim was your way of explaining why you were confident to award most of the costs of the claim. The second argument that is run is simply wrong. It's said you can't make issues-based cost orders. That's just wrong. It's flatly wrong. And the rule we've identified in our skeleton argument is 38.10(6), which says in terms, the orders which the court may make include an order that a party must pay, little 6, costs relating to only a distinct part of the proceedings. That's an issues-based order. And my own friend says, well, it's not listed in 38.12. 38.12 says in terms, these are some of the usual, there are certain cost orders which the court will commonly make. And then it says, final sentence, the table is not an exhaustive list of the orders which the court may make. So the defendants are actually looking in the wrong rule. But anyway, in any event, costs are discretionary. You can do whatever you think is appropriate, and one sees many more wild and wacky cost orders from other judges than this. This is very much within the mainstream. And then the third point is suggested that there was some error in awarding the costs of the claim. Again, that is very difficult to understand. If you succeed on an immediate judgment application, you will, in the ordinary course, be entitled, on the whole of the claim, you'll, in the ordinary course, be entitled to your costs of the application and the costs of the claim. If you succeed on only part of the claim, the ordinary course, you would receive the costs of that part of the claim, because the claim comes to an end. And when else do we get the costs of the claim, if not now? So there's nothing in any of those points at all, and certainly nothing that would come close to the threshold that would be required in the Court of Appeal. And then the final point is the stay application. And this only arises if you grant permission, which of course we say you shouldn't. But if you do, there is no basis at the moment, at least, to stay the judgment. An appeal does not give rise to a stay. That's Rule 44.4. Now, of course, you can stay. The Rule 44.4 doesn't preclude the court granting a stay of execution, but the authorities say the appellant must produce solid grounds, and they have to support that with evidence. And we have directed you to one typically robust judgment of the former Deputy Chief Justice in the Talim case as a pretty punchy précis of the approach that the court will take, and that is at 2629. I don't think I need to read it all out, but essentially what the judge is saying is that the application needs to be supported by evidence. Simply asserting a risk of non-recovery, which was the ground that was advanced in that case, was not enough. The fact of an appeal is not enough, and assertions made without evidence are insufficient. That's the thrust of what's recited there. So the normal course on these sorts of applications is a party says, well, if I pay them, I won't get it back because they'll scarper, at which point the answer is we'll pay it into court. The alternative sometimes is, well, I can't pay that, so if you require me to pay it, I'm gonna end up, I'm not gonna be able to pay my lawyers, and so it's going to stifle the appeal. But all of those, you need a frank.
Well, there might be all sorts of things.
Yeah.
It's going to make me insolvent. I'm going to have to
Yeah.
stop business. There's none of
Yeah.
that.
None of that. So you've got what it is. Just in case, I don't think you've been shown it, but just so you know where it is, the grounds of the application are at 2493. So they start a little earlier, but there's really recitation of rules and so forth. The substantive explanation is at 3.6 and onwards. So 3.6 and 3.7 simply refer to the fact of the appeal. 3.8 asserts the prejudice, which was the primary submission made, which is simply, well, it's going to cost us some significant sum if we do this, and it gets reversed. And 3.9, there's reference to expense, time, disruption to the business. So there's no particulars of that. So it's not said this is the shape of what we'll lose. There's no evidence of that. And importantly, for your purposes, there's no suggestion that they cannot pay. They're just saying, well, it's going to be inconvenient. And that is not solid grounds. Is certainly inadequate. So if we get there, we would say you should reject that application. And indeed, I'd ask you to deal with it anyway, in case another attempt is made further up. Your Honour, unless there are any things that you'd like me to address, I'm grateful. Thank you.
Thank you, Mr. Montague-Smith. Mr. Whitehead, reply.
Thank you, Your Honour. So I won't be too long on this. It's just a few submissions we'd like to make in response, mainly to Your Honour's comments, but also to my learned friend. If I could just take us to page 2058 of the appeal, which is the appeal notice in the bundle. So in the appeal notice, I think there was reference to the defendants not having raised certain issues or points, but if I could just refer us to points 3 and 4, which I appreciate is in a prose. It's slightly difficult to read, so I do apologise for that. But it's I think so. 1, 2, 3. So it's halfway down at point 3, and it reads: the judgment relies upon the case of UBS, which is incorrect as it is not authority on the law of implied terms used in the Singapore courts. The defendants have cited case law from Singapore courts on the subject of the Braganza duty, and none of these judgments rely on the UBS judgment. Accordingly, the CFI has decided the defence is by applying the wrong principles of law and ought to have applied the principles laid down by the courts of Singapore. And then we reference it 4. Further, the CFI has applied the wrong principles of law to the defences raised by the defendants. As such, these findings have to be set aside and should be re-examined in light of the Singapore case law. So I just wanted to just raise that, because I think, you know, we certainly did in our appeal notice mention, you know, what the appeal was relating to. Just in terms of the first point on the lateness of the filing, I would like just to draw to Your Honour's attention that the application was made on the 11th of December. However, the first time that it was contested by the claimants, as far as we understand, was actually at the skeleton argument stage, which was in late January. So in terms of...
Why is that relevant?
Well, look, if it was argued that we had been in any way late or there was some prejudice to the claimant, we would expect it to be done in a timely fashion in accordance with the overriding objective. And if there was any prejudice or damage which had been incurred, then that could certainly have been addressed at an earlier stage. And if it is deemed to be filed out of time, then certainly a relief from sanctions application could have been filed. But you know, we wouldn't go to that extent. But we're saying that it should, if there was a
you
concern.
could have done that when you got their skeleton. You could have done it at any time, but you chose to go forward on the basis that you don't need it. That's what you told me.
Well, you're correct, but Your Honour, my point here is that if there was a real prejudice or if there was a real concern, then the claimants would certainly have raised it immediately, not a month later. Is the point we're just trying to raise there. Second point is the authorities which have been relied on in the decision are not the local authorities which are relied on in Singapore, and obviously this is how the judgment has been arrived at. Singapore law does apply. The parties don't contest that. It is a foreign law, and in our submission we should have a right to lead evidence via a Singapore expert. So we're simply faced with this.
You had the opportunity, you didn't take it.
So at what point, Your Honour, would you say we had the opportunity?
Immediate judgment on the application for immediate judgment.
So for that, what I'd like to come on to here is just some specific RDC provisions. So under RDC 2635, it provides specifically that the judge will discuss what expert evidence has to be filed at the case management stage only. I stress the word only. The appropriate stage for discussing expert evidence is at a case management conference, as was the position in the Singapore case, which I've referred to earlier. And in fact, in other similar jurisdictions like the ADGM, under Section 73, and we've not actually filed that clause as part of this skeleton, but in there's a section in the ADGM, it's Section 73, evidence on foreign law, and that is a specific provision which carves out evidence given by an expert. An expert evidence should be led at trial in our submission on that. And so, yeah, and also, Your Honour, respectfully, we would say we didn't have leave to file expert evidence. Usually in the court, as you're aware, you know, because we've had cases, as I'm sure Your Honour's been privy to, where expert evidence has been filed prematurely without the leave. So we would say, you know, that would be the case. The third point we'd like to make is, obviously, we are faced with a situation where, in our view, respectfully, you know, the wrong law has been applied. But if expert evidence was required, you know, we would say it wouldn't have been at the immediate judgment stage. It would have been at the CMC stage, unless obviously ordered to otherwise. But we still, the defendant's submission is we're being asked to, by, and my learned friend has referred to it, you know, what are the differences? Why should we be asked the differences between the English law and the Singaporean law? Why have we gone to the English law in the first place? And our view on that is problematic, because it's the wrong law to look at in the first place. It's the Singapore law and the authorities which need to be looked at. So in paragraph 90 of the judgment, if I can just take us to page 3228 of the bundle. So this is, my learned friend has filed this, the claimants have filed this, and it's the Application of English Law Act 1993. Yeah, it's at 3228. Now, my learned friend went through various provisions correctly on what the position is, but I think the key provision which we seem to have not addressed is point 4.3. Sorry, point 432. Oh, sorry, point 3.2. Yeah.
3.
So yeah, sorry, apologies.
Yes.
Point 3.2. Yeah. So this reads: the common law continues to be enforced in Singapore as provided under subsection 1, so far as it is applicable to the circumstances of Singapore and its inhabitants, and subject to such modifications as those circumstances may require. So I think we don't dispute a lot of the points which were made in this, but we would still say it's an entirely separate jurisdiction, and obviously with the case law, we would say that there's still no other cases as far as we can see, and albeit the cases were earlier, as referred to by my learned friend, that there's still no other cases which have referred to the UBS and the Marks and Spencers in Singapore as far as we can see. I would like to just refer to Article 44.31 of the RDC.
44.31.
Yes. So this is the grounds of appeal, what it must have or must contain, and there's various sort of requirements which a grounds of appeal must have. The first is set out clearly the reasons why it is said that the decision of the lower court was either wrong or unjust because of a serious procedural or other irregularity in the proceedings in the lower court, and also must specify in respect of each ground whether the ground raises an appeal on a point of law or is an appeal against a finding of fact. So my learned friend mentioned freedom of contract and the fact that the parties have the right to contract and add clauses, and we would say that in this sense, the position is that the discretion can be applied. Discretion is not absolute. There's implied terms and principles under Singapore law. For example, there'll be a good faith provision, an implied term to act, not act irrationally, capriciously, and respectfully, we would say that the court has applied the principles under English law and not the principles under the law of Singapore, and it's come to its conclusion based on English law as opposed to Singapore law in terms of what the breach was. So we've looked at, obviously, a duty of care has to apply, there has to be a breach, and we would say that's fine and that's correct, but that's just been applied under the provisions under English rather than Singapore law. There's just a few more points I'd like to make. So obviously under the law of Singapore, the propaganda duty has to be applied, and the parties must have the opportunity to deal with it. So we would say that there is a triable issue that needs to be dealt with by the court, and in order to do so, we have to look at the terms of the agreement and the contract. If I can just take you to a provision in the contract on this, it's at page 1992 of the bundle. So this is the contractual provision, Your Honour, which you've referred to in your judgment, and it's A2, and I'm sure you're familiar with it. Yeah.
Yes.
But there's just certain things we would say here that even though it still says it's subject to mandatory applicable law. So although it says you save as expressly set out that no implied duties or obligations shall be imposed, we would still say that's fine, but it's still subject to the mandatory applicable law. So for that, we would say
But
that obviously,
that's referring to statutory law and
yeah, the law which is applicable to the contract, the statutory law, and whatever is applicable to the contract. So the Singapore law.
well, yes.
Yeah. So we would say on that the factual allegations and all these points, they've been brought up substantively in the defence, but the point is that they should be subject to a trial. So there is a triable issue which needs to be dealt with on that point itself. There's just one other point I'd just quickly like to make, if you could just bear with me on this. So this is, so look, I've finished my submission with the 1 point on the judge in the case, in the Singapore case, which was the ARJ one.
Deutsche Bank case.
Yes, the Deutsche Bank case. Yeah. So he, obviously, the judge in that case, and I've referred to this before, but at 2399, it was specifically said that analysis on the scope of the Braganza duty in the DIC case is at most persuasive, given that the DIC case appeared to rely on UK authorities on implication of a Braganza duty rather than on any local authority. And then this was then appealed in that case, and the appeal was also dismissed early March. So we would say that a similar approach would need to be taken here in this case. And unless there are anything further there on my submissions, Your Honour.
Yes, well, thank you very much. Well, thank you both for your assistance. I will reserve my decision and let you have it as soon as I'm able to. Thank you.
Thank you very much.
Thank you. Thanks.